Good morning, everybody. My name is Del Daly. I'm on the Board of Advisors for the Center for Ethics and Rule of Law. We'd like to welcome you to our panel today, a multidisciplinary panel on ethics. I'm also speaking on behalf of Mr. Bill Craven, who is our chairman of the board, but unfortunately he's ill and can't make it today. This is a particularly important session for me because of our legal, scientific, medical, journalistic, and national security challenges. All of those have a powerful statement that I use. Who guards the guardians? And the answer, of course, is their values guard. And so today we'll be going through all of the values in each of the respective disciplines there. I would be remiss to not mention the fact that we've got people coming from all over the United States. We do need donations from all the people that have an opportunity, that look at this session today and see that's got value and meaningfulness to all of our goals. I'd like to invite Ms. Claire Finkelstein to come up here now and go ahead and start our official program. Claire?
Welcome, everybody. I'm very excited about this panel, a series of panels today. We have assembled a first-rate lineup for you, and I'm delighted that so many of you came out today to participate with us. I wanted to just take just a couple minutes out of our first panel's time to introduce the center, say a few words about the purpose of the center and why it exists. But I'll keep my remarks very brief because we have each session is only an hour, so I apologize to the panelists for stealing just a few minutes of their time. This is actually a celebration for us of the first anniversary of the Center for Ethics and the Rule of Law. I started the center a year ago and a bit, because I was increasingly concerned about challenges to the rule of law in the face of new imperatives in national security and in the face of the changing nature of warfare. The mission of CERL is to promote and protect the rule of law in its various contexts. National security is currently the context in which threats to the rule of law seem most urgent and most serious. At the same time, a strong national defense is essential given the challenges that we face. We therefore have a number of enormous hurdles and challenges that academics, policymakers, members of the military, people from all different disciplines and all different professions need to come together to think through and to see whether or not collectively we can find a way to balance the needs of living in a society with the rule of law first and foremost among our values, with the exigencies of a strong national defense. There are two purposes to the center in my mind. One is the first one that I've just mentioned, namely the promotion of rule of law values. But the second one is a sort of exercise in academic thinking and in education, which is to see how we can improve our usefulness as academics by uniting with people not only across different disciplines but in different professions to work on problems of importance to us all. And so each one of the conferences that CERL has held have been interdisciplinary and unite practice and theory in the way that I've suggested. We've held a number of conferences involving targeted killing. In fact, our first conference was, as it turns out, 3 weeks before Osama bin Laden was targeted and killed, and then we held a follow-up event, and then there were further developments, and we held yet another follow-up event on targeted killing. All of these activities eventually led to a volume that we published with Oxford University Press, and I do understand that these volumes will be available for purchase, and I'll be happy to sign them, and some of the other authors who are here could also do so. There should be, I believe, other books for sale at various points that some of our distinguished panelists have authored, unrelated topics. After that, we held a conference on cyber war. We've held conferences on the new deterrence. Recently, last spring, we held a conference on sovereignty, trying to understand the changing nature of executive authority and how the new approach, potentially, to executive authority squares with older writings and an older conception of what sovereignty ought to look like. So at each point, what we try to do is to connect current events, bringing a number of professionals from different disciplines and different practices together, with deeper reflection, some of it historical reflection, some of it philosophical reflection on the nature of the challenges that we face. Today's event very much exemplifies this goal, and it is the most interdisciplinary conference that we've held yet. Very excited that we have members, very distinguished members from a variety of disciplines. As you may know, we will hold a first panel on journalists and national security. Our next panel will be medical ethics and the problem of dual use. Government lawyers will then follow, and the role that government lawyers will be debating the role that government lawyers ought to play relative to national security exigencies. Then a panel on mental health professionals and their role in the so-called war on terror, national security dilemmas in the corporate world, and finally the role of scientists and engineers in national security. We will then have a keynote address from Professor David Luban, who is our especially honored guest here today, and then I'll in fact ask a couple of the panelists so that we have a discussion across panels to have a discussion on Professor Luban's talk that'll be very brief at the end of the day, and then we'll conclude with audience questions, comments, and a swank cocktail party that I hope you'll all join us for. We will, in all sessions, allow time for members of the audience to ask questions and dialogue with the panelists. So please have your questions ready, and I will now turn it over to Jeff Rosen, who is our moderator for the journalists panel. Thank you very much, and a warm welcome to all of you.
Thank you so much, Claire. Congratulations on the first anniversary of the Center for Ethics and the Rule of Law. I am delighted to be here. I am Jeff Rosen. I am the new president and CEO of the National Constitution Center, and this, I hope, is one of many collaborations between the Constitution Center and Penn Law that we're just thrilled about. I'm also a law professor and journalist myself, and I'm just so looking forward to this panel and to learning from my colleagues. I'm going to introduce them very briefly, and then we're going to jump right into this fascinating question: what are the ethics of national security reporting? I'm joined in alphabetical order by Jane Kirtley. She is the Silla Professor of Medical Ethics and Law at the School of Journalism and Mass Communications at the University of Minnesota. Kevin Smith is the Deputy Director of the Kiplinger Program in Public Affairs Journalism at The Ohio State University, and Dr. Stephen Ward is Professor and Director of the George S. Turnbull Center in Portland, Oregon. Jane, I'm going to start with you and just jump right in. Is Edward Snowden a journalist? What does it mean to be a journalist in the age of WikiLeaks?
You know, one of the great things about being in the United States is that we don't define journalists, because we can't license journalists. It would be contrary to the First Amendment. I think the question is not whether someone is a journalist, but whether someone does journalism. And my definition of doing journalism is someone who collects information with the purpose of disseminating it to the public. There was a time, not all that long ago, where it was really impossible to make a mass distribution without using an intermediary, like a mass media organization. Snowden, of course, is moving into the era where it's actually possible to publish to the world without the need of an intervening editor or any institutional thing. So I think I would think of him as primarily a source of information, but is he doing something that looks journalistic? Yes.
Stephen, is he a journalist? And what's the difference between Snowden and Glenn Greenwald?
Oh, well, I take it the Greenwald works extensively for a major news organization. Yes, I think you can commit acts of journalism, anyone. Random acts of journalism, even. I also think that I agree with Jane. The big question is not trying to define question. I see that a justice panel couldn't even agree on a definition, or they struggle even with that one. There's always political motivations when you want to define what a journalist is. Well, we don't want WikiLeaks to be included, so therefore we're not going to include them. I would say that the more important question is it good journalism? Is it bad public journalism? What are the norms that are driving the journalism, and so on and so forth? That's the real issue.
Any dissent from this idea that a journalist is someone who collects information with the purpose of sharing it with the public? Is there any responsibility to filter, to make judgments, to edit? I mean, is all of what WikiLeaks did journalism, or is there some of it a document dump?
Yeah, I would agree exactly with that. I think that, the short answer is he a journalist? I would say no. I think there's as with anything, there's a dictionary definition of journalism, and I think that, Jane and Stephen touched on that very well. Someone who collects information and disseminates it. But those of us who have been in the profession for a while know that if it's just a matter of collecting information and disseminating it, then that to me is a very restricted definition that's based on, sort of a dictionary definition. But I think there's a lot more components to being a journalist. There's ethical components, the legal understanding, the perspective, the editing, the various other things that you'd mentioned, right?
Well, say more about what you think responsible journalism requires. What sort of judgments can distinguish a journalism from a document dump? How do journalists actually collect and filter information? How should they do it? But let's stay focused on WikiLeaks and what part of it. The New York Times made some judgments that some stuff was worth publishing and other stuff should be withheld. Is that journalism, and what Assange did is not, or just help us hone in on the definition?
Well, I will pick on one thing, and I'll let the other panelists chime in. But I think motivation is certainly a key factor. Well, what's the motivation? If you've collected sensitive information and you just wholesale deliver that in a venue that allows everyone to see it. My question is, what was your motivation, or what is your motivation for doing that? And I think that journalists need to be asked that same question. Every time they write a story, what's your motivation for doing the story? What's your motivation, for the sources you use, or for not using a named source? So I would say one of the primary questions I would use to differentiate is to go to the motivation of the individual who has the information and what's their intent.
What do you think, colleagues, about motivation? And what if the motive is just to embarrass America? Does that mean it's not journalism?
I as speaking both as a lawyer who worked with the news media for many, many years, as well as somebody who does media ethics, I get very scared about the prospect of people probing journalists' motivation. Does anybody have a single motivation for anything they do? It reminds me in a way of an era about 10 or 15 years ago when the focus became not the story that a journalist told, but the way the journalist got the story. In other words, the focus was on the news gathering techniques, and Jeff, I know, and others are very familiar with this idea, the Food Lion example of going undercover to reveal problems with food practices. The focus became, you lied to get in and do the story, not what the story was. So I'm very wary of saying that the criterion for deciding whether somebody is a responsible journalist is probing what their mental state was or their motivation was. I think everybody has mixed motives for what they do. For me, the bottom line is, are you gathering information for the purposes of disseminating to the public? And there's advocacy journalists out there. There are people that don't engage in advocacy journalism, but I would protect all of them.
Stephen, let you continue the conversation. Let's hone in on leaks. Let's imagine you're collecting information and breaking the law.
Right.
The technology of leaking has changed through sites like WikiLeaks, and we no longer have to go through intermediaries. In the past, we had journalists protecting whistleblowers and having confidential sources. Now you can have people like Snowden just directly breaking the law with the purpose of disseminating the information. Does this change in the technology change the way we think about leaks?
Yes and no. to walk right on top of the, not to take a position. I think it does because, when we talked about leaks when I was growing up and, dinosaurs roamed the earth, there was the sense of leaks was gotten by, well, yes, information laws, although they don't work that very well for journalists. Yes, the lonely act of investigative journalists, trying to get somebody to give you some information inside the government and so on and so forth. Now, yeah, that changes now. You can sit back, set up a website, have some encryption technology, and watch it roll in. I think the decisions on what you do with that information probably in the main remain the same. If you're going, to jump right into it, if you're going to, and this depends on what the ethical framework you're coming from. I come from the framework in which I define ethics in journalism very simplistically as the responsibility in using the power to publish and the right to publish. And so it entails a certain limit, a certain balancing of norms in the exercise of that act. In terms of leaks, first of all, I get a headache when I think about this too much. Number one, a judgment on the importance and nature of the information in front of you. It's very difficult in the abstract to say, would I publish this? What are you asking me to publish? And a judgment on the importance, and we can talk about that. Judgment on the reliability, judgment on the vetting and reliability of the documents, even if they come in encrypted forms. Who did it? Yes, what is their motivation? We should always look at motivations of people giving us money and their agendas. But can we cross-reference it, cross-source it, and when we do publish it, will we give it any context? Or will we just throw it out there? And the other two, then it is, are you going to publish this? First of all, what are the impacts of publishing that? And there's going to be a whole bunch of different, and there's a vague area. Sometimes we're only working in the area of conjecture. We think someone might get killed down the road out of this. We think there might be some damage to diplomatic relationships and so on. And finally, if you do decide that the public interest is served, and there's that big word, public interest, the public interest is served in general, will you minimize any harm? Will you publish it in a certain way that certain names are redacted and things like that? So my view on this is it's an incredibly complex decision to do this responsibly. And I think those, in the main, still remain the criteria. So that's the no part, no, it hasn't changed. I still think we need to go through that process.
Well, that's a very thoughtful answer, which is well worth discussing. So Stephen has said basically there's a bunch of factors, not just the motivation of the leaker, but also the accuracy, context, consequences, and most important, a judgment about whether or not the disclosure serves the public interest. Jane, what do you think about that?
I would agree with much of what Stephen said. I think that the tricky part, and this is what I've heard for many, many years in the work that I've done when I've spoken to people from the intelligence and national security communities, is they say, who are you as a journalist to make those kinds of judgments about what the damage is likely to be, what the public interest is, who elected you to make those decisions, and what accountability is there for the consequences? Because, as several Supreme Court justices have observed in a number of cases over the years, if bad things happen, the American people will know whose fault it was, and it'll squarely rest with the press. And yet, I don't think we've ever seen that set of consequences arise. Maybe because the revelation of this information really hasn't had at least the kind of visible, tangible harm that we often hear cited from the intelligence community. So, to that extent, I would agree with what Stephen had to say. The other point that I just would like to make quickly is that I think there's been a practice, at least with the mainstream legacy news media over the years, that when they were the recipients of leaks, one of the things they did, in addition to trying to verify that they were what they purported to be, was to talk to people in the government, their sources in the government, to try to get an assessment from them about what the likely damages were going to be. And I remember a number of years ago, Ben Bradley, who was the editor of the Washington Post during the whole Watergate era, wrote an op-ed piece in which he explained that this was a practice that the Washington Post followed. And a lot of people were really shocked to hear that. They thought it was really not appropriate for journalists to be going sort of hat in hand to government to say, what will happen if we publish this. But I don't have a problem with that for two reasons. One, because I think it makes, for a better decision-making process rather than just willy-nilly reporting anything you get and making your own judgment about what the consequences are likely to be. And number two, here in the United States, it's actually safe to do that. Because thanks to the Pentagon Papers case, a journalist doesn't have to worry about what would happen to a journalist in the United Kingdom, for example, where a D notice would be issued, the Official Secrets Act would be invoked, and there would be real risks of consequences if the news organization went ahead and published. So that's one of the good things about the protection we have under the First Amendment, that we can actually have that dialogue and not run the risk of being stopped from publishing.
So we have two votes essentially for some judgment, but Jane also notes this could be elitist, and who elected the journalist God? Is there a case to be made for total transparency, or are consequences always important? And I want to give a particular example. One of the things that came out in the WikiLeaks disclosures was a false allegation against a European politician of sex crimes. It was later exonerated, proven not to be true, but the publication of this deeply damaged him. Does that matter, or should it just all come out?
No, I definitely think it matters. Again, I think it goes back to, what the purpose is here. And I understand from a legal perspective, and Jane touched on this, and I'm glad she did. From a legal perspective, no, you don't want to be in a situation where you're having to defend what someone's motivation is or what their thought process was at the time. But from a philosophical standpoint, if you're a philosopher, that's a very core of a lot of those things, of those types of discussions. What was the motivation, or what was the inspiration for you to behave in such a particular way? So the answer to your question, does that matter? Yeah, I do think that extremely does matter. Do you just put it out there and let the chips fall where they may? I mean, I think this is how I look at it. You have someone who is in possession of sensitive information. They are employing a certain set of ethical standards that sort of determines whether they think that information should be released. They believe that their set of ethical standards is the best course of decision making. They do not want to turn it over to journalists, right? Turning it over to journalists is probably like akin to leaving a toddler at home by himself all day, right? Only bad things are going to happen, right? And so they are not going to, they're not going to leave the ethical decision making to the journalist. They would rather have that decision, as to whether that is private or whether it's sensitive information. They would rather have that decision left in their hands rather than turning it. Now, journalists, on the other hand, see it as, in the process of information gathering. I think they would just prefer you to give them everything and then let them employ their ethical standards as to whether they think something should be published or not. And so you have two sets of, variations here. One says, if I release it, then these less ethical people are going to commit all kinds of heinous behavior. The journalists, on the other hand, are saying, you just leave it to us and we'll do it appropriately. And then I think that's, a large part. That's sort of a very simplistic, dumbed down way of saying that's some of the issues here.
So consensus against the ethical nature of total document dumps, and a sense that some filtering is necessary. Let's talk about the technology of leaks. So Assange's right-hand man, Daniel Domscheit-Berg, who broke with Assange, published a book saying that WikiLeaks is too transparent. It's wrong to have document dumps. Instead, we should have digital drop boxes where people can put classified, encrypted information and direct the filtering organization to which they want to send it. So you can say whether you want it to go to the New York Times or the Guardian or something like that. Is that a better model than WikiLeaks, Kevin?
Yeah, it's not going to happen. In today's real world, and what we're not talking about is all the people who don't want to follow ethical norms, who believe and justify that in the name of sort of a total transparency of information against the big bad state and the secrecies of state. I think the mainstream, I keep using the word mainstream, what is that, right, anymore? But I do think that news organizations should vet this stuff and as I've said before. The problem with all of this talk is that, someone said, well, who gave you the right to publish this? Well, look at the 400 years history of modern journalism and the fight for freedom of the press. It probably goes back intellectually. The idea of transparency probably goes back as far as Jeremy Bentham and the notion of publicity as a counter-political weapon against hierarchical governments in the Enlightenment public sphere. And the journalists and the rising newspapers in those days were seen as fourth estate public representatives. Journalists still see themselves that way. But it's a very simplistic answer to say, well, the ethics is part of our social role is to act as watchdogs. Then the question, however, is, the really tough question is what sorts of information do you define as harmful? Journalists, ethically in my view, do harm every day. The principle cannot be avoid harm. If I publish that you were arrested for sexual molestation and went to court, I've hurt your reputation. If I write that McDonald's hamburgers at a certain chain were made people sick, I've damaged their business. It's a question of justifiable harm, given one's social role. And the social role here, what is it in terms of national security? Well, the social role is we're supposed to inform the public about what their government is doing, yet at the same time not do serious harm to the national interest or national security. So I'd like to put on the table, what the hell does national security mean in the first place? Because that is a squishy concept. Use it in one way and you put very strong fetters on the press. Use it in another way and you've opened the doors to really harmful information. I believe there is harmful information out there and that in fact should not be published. And I would also point out, just to be maybe some of you disagree, but if you look at the history of journalism and current practice, non-transparent practices have been with journalism from the beginning. I use them. I gave confidentiality of my sources on many important stories. That's not telling the public everything, is it? And I think it was perfectly justified in those areas. In many cases, I've minimized harm by not naming young people caught up in tragic family stories and identifying them. I was not perfectly transparent in my story. And I could list more non-transparency activities. In many cases, it is felt in investigative journalism that we are going to protect our sources and be non-transparent, because that's the way to get to the bottom of this. I don't reveal, I'm no longer a journalist, but if I was writing an expose on a biker gang and had an inside confidential source, I would not name them because they'd be dead tomorrow. So the argument is falsely poised as, is it all transparency? Is it all non-transparency? The difficult question is in the middle. Those types of information where you say, yeah, this way and that way. And for that you need what Aristotle called phronesis, practical wisdom, with the norms that we've just mentioned. I better stop. I'm making a speech here. I'll stop.
No, that was good. And you question what national security is, and you said there could be justifiable harm. Yeah. But let's dig in about what sort of national security leaks are not justified. Is there anything in the Snowden or WikiLeaks disclosures, Jane, that you think should not have been published?
Well, I think that there is a difference between leaking diplomatic cables and leaking information about probably illegal government surveillance of American citizens. I think there is a big difference between those things, both in terms of, I would say, the necessity of the public being aware of it and the probability that harm is going to result from the disclosure. Again, we've been hearing from the national security community forever that if any of their secrets are told, horrible things are going to happen. And it's often very difficult to pin that down in any kind of concrete way because you'll be told that that too has to be classified. And I think that's at the core of this, which is that even the Information Security and Oversight Office will tell you that overclassification is endemic. It didn't start with this administration, but it certainly has continued under the current administration. And so therefore, I think this kind of all or nothing dichotomy that several of the speakers have referred to is really at the core of what the problem is. Freedom of information laws in the United States are not as useful as they could be in providing a tool for the public and the press to monitor what government is doing because of the national security exemption for quote-unquote properly classified information. I guess to go back to the question that you asked about the digital Dropbox, one of the things that I think is unfortunate about the reality of that is that it's not going to be anonymous. It's not going to be secure. Anybody who thinks it is kidding themselves. We're learning every day more and more because of leaks to the media about the capacity of the government and the NSA to conduct surveillance. I would have no confidence whatsoever if I was running a news organization that if I set up a digital Dropbox that I could actually guarantee confidentiality to whoever was providing me with that information. And I would feel an obligation to be able to do that if I was setting up a system like that. So to me, it's all a snare and a delusion to pretend that we can have any anonymity in the digital world. The reality is we can't. We don't and we can't. And I think that what we're seeing, at least among journalists that are fully aware of this, is a return to old-fashioned reporting methods, whether it's meeting Deep Throat in the garage in Washington, D.C., but you're meeting face-to-face. You're not using digital communications because there's simply no way to guarantee the kind of confidentiality and security that journalists historically, whether rightly or wrongly, chose to promise to their confidential sources. I want to say one more thing really quickly. Stephen mentioned the concept of the fourth estate. I've always thought that the fourth estate is also a trap for journalists because it seems to me that when you use a phrase like fourth estate, you are suggesting that journalists are, part of the establishment, who have a stake in maintaining the establishment. I think the most effective journalists are the ones who are on the outside, with their nose pressed up on the glass looking in. They're the I.F. Stones of the world who, are proudly not part of the Washington elite, the Washington establishment.
Yeah, I agree with that.
And so, I don't disagree that people use the phrase all the time, but I wish more journalists would repudiate it. And I think the rise of sort of alternative media is directly a reflection of that, of the public's suspicion and concern that news organizations, as they have existed for the last, 50, 60, 70 years, have such a stake in maintaining sort of the status quo that any saber rattling they do is really just around the edges. And at the bottom line, they're still playing tennis with the guys from the CIA.
Yeah, I agree that that you want to ignore that, watch that term and those implications. There is the fifth estate, which is the alternative media that grew up in the 20th century. I call for a sixth estate. I'm just going to keep going estate all the way. I'll just never leave the word. The sixth estate is where we all monitor both online and mainstream media equally. But never mind. Let me put this to you. If the types of information that you would think would be justified as a journalist to publish, let's think of it as a continuum from yeah, probably to no, never. Yeah, probably would be government illegal activity. Then move down the line to government lying and misleading the public, even if it is not technically illegal. Then you move to, let's see, what would be the next stage? The next stage would be, I would suspect, unknown policies that the public should know about. And then maybe on to that to situations where we produce embarrassing information. In the debate over WikiLeaks, all of those have been thrown around, confused, and so on. Let me give you an example of what, just the word we shouldn't, is it possible that diplomatic cables are embarrassing and would somehow hurt American sort of relationships with their allies and other people. How, in what area, what type of cable would actually be so damaging, or set of cables, that you would not publish it? I don't have the answers, I'm just throwing them out to you. Here's an example why you would not want to take embarrassment as just a clear criteria. I've been called unpatriotic. I'm a Canadian, but I live in the United States. As a foreign reporter, I was called unpatriotic more times than any other Canadian journalist between when I was a foreign reporter, because I reported on embarrassing things about the Canadian military and their peacekeeping activities and so on. So you have to be, what I'm saying, and basically it was everything was undermining the morale that I wrote. Everything I did was sort of working against Canadian interests. These are big, fat concepts that are not sharp enough to do the ethical work in journalism, in my view.
Well, Stephen, you mentioned, are there some state secrets that are so embarrassing that they shouldn't be published, that they do genuine harm? And I want to raise the question of prosecution of journalists and publishers who publish those state secrets. And here's a specific case. So the Office of Legal Counsel, which is the office in the Justice Department that provides advice to the President, has just published a riveting volume of previously secret opinions between 1937 and 1976. They've just been declassified, and one of them involves an effort to prosecute journalists and whistleblowers under the Espionage Act of 1917. This is the same law that's now being invoked against Edward Snowden, and some invoked it against James Rosen. Here are the facts. This is the Battle of Midway, June 7th, 1942, the Americans have won, and the Chicago Tribune, which is published by an isolationist, opponent of FDR, prints a detailed description of Japanese troop ships as part of a story revealing that the U.S. has broken the Japanese naval codes and is reading its encrypted messages. The story is part of the publisher's campaign against what he considers the Roosevelt administration's secrecy and incompetence, but the administration believes that the Japanese now know that the U.S. has cracked their code, and the Office of Legal Counsel in this previously secret memo says that both the newspaper reporter and the publisher of the Chicago Tribune could be criminally prosecuted under the Espionage Act for publishing naval secrets. What is your reaction to that recommendation?
Something that happened years before I was born.
Yeah.
I think this sort of takes us, ping-pongs us back to the conversation at the beginning. Jane will probably hear this story and think of it from a more of a legal perspective. As you're telling me this, I'm thinking, I hear the publisher, the accusations that the publisher has an agenda. And I go back to, the purpose of doing this is the motivation of one individual or one newspaper to sort of what they believe is the appropriate behavior or actions against the government or a particular sitting president. And so I look at it from that perspective. I think that national security is, it's the perfect oil and water ethical issue for journalists. If you've listened up here, Stephen's 100% right. I mean, everything we do causes some amount of harm. And if you look at the Society of Professional Journalists Ethics Code, the first tenet is seek the truth and report it, and talks specifically about how you should commit yourself to the cause of truth and accuracy and reporting things and informing the public. And then the second tenet that follows up after that is minimize the harm that you do. And teaching ethics over the years, students seem to, I hear students talk about, even professionals hear that and they say, well, aren't those two, opposites? Yes, they are. But it's a balancing act. It's about your obligation to report information that the government has, and being transparent about that and putting the government on notice that you are the informers to the public. But it's also realizing, and I think this is really the difference between someone like Assange and a journalist, in that is it's not just about taking the information and putting it out there. It's about having thoughtful, ethical, responsible processes to say, what harm am I causing? And I think Stephen and Jane have touched on that quite a bit.
The harm here, though, is breaking the law. And the question I have is it ever appropriate to prosecute journalists and or publishers for breaking the law? And in particular, are Espionage Act prosecutions, Jane, against publishers ever appropriate? In this case, the Chicago Tribune wasn't brought. There were no charges brought. But
Yeah, and
publishers
my
never
answer is no, it's never appropriate. And I'm going to take a very simplistic reason for that answer, and it has to do with the First Amendment, but it's collateral to it, in the sense that because we don't, at this point in this country, have an Official Secrets Act, the reality is that a non-governmental contractor, employee, et cetera, has no legal obligation to maintain the secrecy of government information. The Supreme Court Justice once said journalists can ask for information, and it's up to the government to keep its secrets, and I agree with that. I think that ultimately it would be unconstitutional to prosecute journalists under the Espionage Act for simply publishing information. Now, the trickier question is what happens to their sources.
Yes.
And we've seen prosecutions in the past. We have a number of ongoing cases that the Obama administration has launched, more than ever had happened before, have just happened in this administration.
6 cases.
6 cases, which again, if you think of it, I suppose, in the abstract, that doesn't seem like that many, but to me, each one is a profound question about the public's right to know and the balance between that and the authority of government to maintain secrecy. But although I have been very concerned, certainly since the late 1980s, about the attempts of government to sort of gradually set up the system that would allow them to prosecute journalists under the espionage laws, by beginning with the case involving a naval contractor who leaked information to a British publication called Jane's Defense Weekly, and who was prosecuted under the espionage for leaking to the press rather than to an enemy agent or an enemy government. So I thought that's stage one. Then we move into some other cases, including the ones involving the AIPAC lobbyists, for the crime of basically asking for information and getting it, which is what journalists do. Now we've got James Risen, we've got the Rosen case, or the possibility of the Rosen case. I think my view is that the government moves very deliberately. It does not want another Pentagon Papers pronouncement from the Supreme Court that says essentially you cannot restrain the press except under the most extreme circumstances, and it's never been allowed. They don't want a similar ruling saying the espionage law can't be used against the press, so they will wait, and it may not happen in my lifetime. They will wait until they've got the case that they think is really compelling. I don't think that case has occurred yet. I hope it does not. But I think prosecution under the espionage laws, simply for publishing information that has been leaked to you without some other criminal act like breaking in and stealing it and so forth, seems to me to be unconstitutional.
Stephen, is the problem the espionage law itself, which in the Chicago Tribune case, by the way, faced the possibility of a death penalty for the leaker? And thankfully, the OLC recommended against the death penalty, although it did prefer a prosecution. But, so in other words, is it the espionage law in particular, or do you think, Stephen, that leakers should never be prosecuted under any law, and they should, the government should be powerless to enforce those secrecy laws?
Yeah, well, I'm more on Jane's side of all of this and lean towards her. I wouldn't be so absolute as to say never, ever prosecute anyone, because I'm sure somebody in this hall could think of an example where it probably is justified. But I would think the tendency and inclination would be to fight that and resist that, and particularly with the press, fight it even and resist it even further. So, law isn't my area, but certainly I agree with most of Jane's comments.
And just finally on the espionage question, Kevin, does the fact that there's a consensus that leakers can be prosecuted, but journalists generally shouldn't be, is that the difference between a journalist and a leaker? I mean, the law does treat them differently in that sense, even though any leaker could claim he's a journalist just by starting a blog.
Yeah, that's a great question. There's right now, and has been for quite some time, an attempt to get a federal shield law to protect journalists whose sources, leak them information. And I've been a part of that. I'm not ashamed to say it, as in the journalism organization that I once was president of and lead. We have spent, several years lobbying for a federal shield law. And in every bill that has been introduced, there has been language that speaks specifically to national security issues. and that those decisions about the determination of what constitutes national security issues to be determined by an impartial judge. In having conversations with senators and congressional members, that has never been a sticking point. I should say it's been a sticking point with certain senators, but from a journalist standpoint, it's never been. We have always advocated, and I have said, coming from my mouth, journalists understand national security issues to the point that, nobody wants, I don't know of a single journalist in a traditional form, I'm thinking who would want to put information out there that's going to cause harm to our military, our Secret Service, our anyone who is involved in terrorist preventions or anything. I don't think we have to convince the Congress that is not the motivation of journalists, and national security clauses have been in every shield law that's been moving forward. Now, then.
Yeah, and I think we shouldn't lose track of we should enlarge our perspective and think about how other cultures, other societies deal with these issues. With the First Amendment, and I know there's lots of complexities around it, in the United States, as Canadian journalists, we used to look across the border and just say, I wish we had a First Amendment. But how does Canada deal with it? Let's just take the country. Well, it's a little more mushy, a little more messy. The Section 2B of the Charter of Rights and Freedoms in Canada says, recognizes freedom of the press, freedom of expression and media, but Section 2A, just before it, says those fundamental rights can be restricted. And so it's a difference, and so it falls to the courts in many cases. Recently, about 2 or 3 years ago, a very senior court in Canada said that journalists had responsibility journalism protections, meaning if it could be shown that the journalism was done in the public interest and was not done recklessly, that in fact you might be under some protection from libel and perhaps other prosecutions. The other thing that the assumption that's grounding this conversation, that I'm just going to throw out before our time empties, is that is basically, and we don't have to discuss it, but what we're saying is that the ethics of journalism is based on a larger political ethics. That is, not harming my country. So journalists are citizens first, they have obligations to the country, national interest, and then they start plugging in the journalism ethics. I think a lot of people out there, specifically stateless websites, stateless meaning things like WikiLeaks, might not subscribe to that. But anyway.
I think, ladies and gentlemen, we have 10 minutes, and therefore it is time for your questions. May I invite them now? Yes, sir. That's pretty good. Give it a try.
Okay. One thing is that, thank you. It seems that there might be a little bit of a reversal. It seems in my mind. A lot of the time, well, there are situations, it seems, when things basically really crimes are committed, right, via journalism, and that's punishable by law. We have legislation. Statutes regarding, leaking certain things during times of war. These are all legal things that can be, seems to me, prosecuted and deserve prosecution if that can be proven in court. But before that's done, and also that acts as a deterrent to committing crimes, especially if, well, death penalty is pretty scary, deterrent. And the other thing is, before crimes are committed, to impinge upon the liberty of people who have actually not committed a crime just because such a crime is possible is made necessary. Well, basically it seems like the opposite. Yeah. It seems like the reverse.
So is there a distinction between prosecuting people for crimes after they commit or locking them up for crimes that they might
That
commit?
they might be thinking about committing, you mean? I mean, I remember talking to a lawyer from the former Soviet Union one time who said, you know, we can keep you in jail for a period of time to figure out if you're thinking about committing a crime. So I'm not quite clear, and I don't mean to dodge it, but I'm not quite clear about the question. Let me just answer the question I want to answer. That's the great panelist ploy, right?
Looking like a true
again, I think what it comes down to is legal obligations. And until the day that we have an Official Secrets Act in this country, and one was passed in 2000 but vetoed by President Clinton, but until that day comes, I'm with those who interpret the espionage law to say that journalists and others who do not have a legal obligation to maintain the classified information cannot be subject to prosecution under the espionage law as it's currently written.
That's great.
Jeff, can I ask you?
You've got the mic? Yes, sir. And then
I might add a question, but it's exactly related to that. So that's not true. So let me pick up on Jeff.
Maybe people asking questions should introduce themselves briefly first. Yeah.
Marty Lederman, Georgetown Law Center. So let me pick up on Jeff's story of the war, just as a demonstration of how things have changed and how the government doesn't use the law the way it could to prosecute journalists and what that means. It wasn't OLC. OLC didn't exist at the time. It was the Solicitor General's office.
it was published by OLC in a volume that was called a volume of OLC memos.
Not correct. OLC published a volume of opinions issued by the Office of Solicitor General before OLC became an office.
Marty, you should say that you have some professional interest in defending the
Yes,
reputation of OLC. Why don't you tell
I
me?
used to work in the
You
Office
did.
of Legal Counsel, but not in the Second World War.
But you
So
did
Oscar,
work. But
Oscar Cox, the Deputy Solicitor General, wrote this opinion. The case was prosecuted. It wasn't secret at all. They went to the grand jury, and the case fell apart for the reason the cases usually fall apart, which is that the intelligence agencies weren't willing to put, it would have been more harm to them to have the trial and put on public display the harm that had been caused by cracking the Japanese codes. And so the evidence was very threadbare, and the grand jury decided not to bring charges. What's interesting is that after the war in 1950, Congress passed a law still on the books that absolutely prohibits, no ifs, ands, or buts, the publication of any information concerning communication intelligence activities of the United States, Section 798. That law was supported by the American Society of Newspaper Editors as an absolute prohibition, and that wasn't done. Communications activities, intelligence activities were never published about until the mid-70s, when they began to be published about. And now every day you pick up the newspaper, and that's in the newspaper, and I'm sure your lawyers will tell you this flatly violates the statute. The only two Supreme Court justices to have spoken to it said it wouldn't violate the First Amendment to prosecute you. And yet the government has decided, I think very wisely, that what seemed like obviously impermissible journalistic activity in 1950, we have to just accept today. It's become the norm, even though it's absolutely against the law. You asked whether there would be a test case. It's very interesting. The McClatchy incident, I want to know what you guys think about this. From a few weeks ago, so McClatchy actually published, the New York Times refused to until McClatchy did. McClatchy published that we had gotten communications between al-Zawahiri and the head of AQAP, thereby blowing that form of presumably disclosing that we had broken some sort of communication between them and making that source unusable. According to the New York Times or the Post this weekend, that caused an enormous amount of damage. We lost that communication capability, much greater than the Snowden disclosures. If there were ever a case for prosecuting under 798, it would seem to me it would be against McClatchy here. I doubt that's in the works. I don't think that's going to happen. But I'm just curious what you think about whether McClatchy ought to have published that we had gotten access to al-Zawahiri and AQAP's internal communications.
Jane?
The 798 thing, I mean, I'm going to show my age here because I remember when there was the publication of the name of one of the programs, the Ivy Bells program. I think it was in the 1980s by NBC, as I recall, and there was a major cause célèbre about whether there was going to be a prosecution or not, and, for whatever reason, the government chose not to do it. And I guess that's the distinction that I'm inclined to draw. Naming Ivy Bells, the Communication Intelligence Program, technically was a violation of that provision of the statute, but they chose not to go forward with the prosecution. hard to answer the question of whether they should have published it or not, but I think reasonable people could differ about whether the benefit to the public outweighed the potential for the harm there.
You know, since Marty mentioned it, of course, the Obama administration has been strongly criticized for having justified the legality of the PRISM surveillance program, among others, in targeted killing. Do you believe, and we don't have all the memos written by OLC or others that were used to justify these programs. What does the panel think about the importance of releasing those secret OLC memos so that we can see the justifications on which the administration is relying?
For me, it comes down to this. And this may sound, again, very simplistic. I don't believe that the government has to tell all its secrets, but I think the government has an obligation not to lie to the public. And we have a pattern in practice of certain representatives of the intelligence community lying, at least to the public, and for all I know, to Congress as well, about the scope of a lot of the intelligence surveillance activities. So for me, that's really what it comes down to. If what we would learn would demonstrate that it has been misrepresented to the public, and we're not supposed to be government's not supposed to put out disinformation to the American public. There are specific laws about that, in fact, in terms of some forms of communication. So that's the key for me. If they're lying about it, I feel much more comfortable with going forward with publishing it.
Oh, can I say
go
something
ahead,
here?
please.
You know, I would agree with that to a degree, but I think times have changed, and I think that there is less and less transparency in government from the federal level all the way down. And I would say, yes, the government doesn't have to tell all of its secrets, but God, more and more things are becoming secret. And I mean, that's at the federal level, the state level. I mean, our organization hears complaints from one end of this coast to the other from small municipalities holding meetings and making records unavailable. I mean, the myriad of excuses for hiding government activity from the smallest level all the way up to the federal level is just rampant. It's out of control. And yeah, while I agree with Jane that I don't think that they should tell all their secrets, I don't think they should continue to stockpile secrets at the rate they're doing.
Jeff, we've given the microphone to two people who were trying to get in. I
Please, yes, ma'am.
apologize for...
That's just great.
I'm Kate Gibson. I'm at the Iran-U.S. Claims Tribunal. I'm a bit of an outsider on this, which maybe means I'm a bit more neutral. But my question is, when a journalist is making a decision about whether or not to publish a certain information, does it matter what the source's reason is for confiding in the journalist with that information? If it's a disgruntled employee, if it's a person who themselves has sort of harmful intentions towards the United States, or if it's just somebody who has a mental illness. If this is information the journalist would otherwise know, there's no way the journalist would have this information. Does that play a role in your consideration? Thank you.
Well, you know, I don't know what the rest of the panel feels, but it is relevant to the extent that any time anyone gives you so-called confidential or any information, you have to ask why are they giving you this information. You have to, there could be misgruntled employees, and therefore you have to look into all of that. But in the end, it's whether what they gave you is true or not. That's the touchstone, and you have to vet it, cross-check it, and so on and so forth. My point about many of the so-called transparent websites right now is that they're reckless. That they're not doing what I've been talking all through this panel about, which is vetting, cross-referencing, going through the much slower process. So that I'd say yes, you have to take it into account, but it's not a knockdown veto or a type of reason you wouldn't publish it.
I'd agree with that. I'll just add one quick footnote to it. When Edward Snowden made his initial disclosures, my first thought was, this is really good. It's really important that this information get out there. When he then went to Hong Kong and then to Russia, I confess, I was conflicted at that point because I thought, what was his real motivation here? And I was having a lot of trouble separating in my own mind the issue of his motivation and the information that he revealed. I think it is a very complex question.
You're almost out of time. We have one more person with the mic, and then I'm going to take one last question. So yes, sir.
Greg Block from Georgetown and the Center for Transnational Legal Studies. I suppose that the non-centralization of the mics is a metaphor for this panel. This conversation assumes a vibrant thriving journalistic community. But in fact, we've seen a field and a profession in economic collapse. And a whole lot less by way of resources devoted to this kind of labor-intensive effort than happened through the early and middle of the 20th century. So the question I want to ask is, in light of this, the collapse of this field, should these protections be extended, and a few of you touched upon this earlier, to lots of others, to law professors, for instance, who might occasionally do this work. Some of the folks in this room have done some of this work. To other academics, and to other folks without perhaps any constraints at all. Is this perhaps not a professional ethics question, but a policy question that should not be understood in terms of professionals?
I think it's even broader than that. I think we're now moving into an era where ethics is for everyone, because we all can potentially produce, not just consume information. And I would agree that those rights are if I understand you correctly, should be extended. But the problem is how and to what degree. The idea, the wrong impression to give is that there's a priestly class of virtuous people called called the professional working press. It's not that simple, and I'm sure Kevin would agree there's some bad professional journalists out there. And yes, the economic models undermine their dominance, which means we have citizen journalism, we have social media, we have all kinds of people doing acts of journalism out there. I would think, as a matter of just general philosophical principle, yeah, why wouldn't the laws be extended to them?
And I guess I would just add that I think the danger of trying to decide who gets to invoke this is something that we're seeing over and over again. From a U.S. constitutional law perspective, it is very dangerous to try to define protections in terms of somebody being a quote-unquote responsible journalist, as they talk about in Canada and in the United Kingdom. So, my view is if you're doing the journalistic practice, whatever the privileges are, you should be able to invoke them.
This is the last question. It's going to have to be short.
I wrote the memorandum back in 1985 addressing the issue of prosecuting or illegally either bells information. And so my point was, since this panel specifically is addressing the issue of national security, what amongst the panel members, if you've ever worked, as I have, in the mosaic theory of intelligence gathering, using sources and methods, what confidence, since the people through their representatives have created a notion that certain aspects of the country's business when it concerns national security should be conducted in secrecy. I mean, you couldn't have a classification system if that weren't true. What is it that gives individual journalists the notion that they understand enough about the ramifications of what they are publishing to go ahead and publish information that can lead to the compromise, as one of the earlier speakers noted, of significant sources and methods? And I did, in my personal experience, see communications links that represented the most productive source of international intelligence information available to the U.S. government dry up because it was specifically published that they were the product of communication intelligence activities.
An important question, Jane. I'm going to give it to you. How can journalists know?
I would say two quick responses to that. I actually spoke out at Bolling Air Force Base one time about topics related to this, and a guy in the back of the room stood up and said to me, "I have just one question for you. Aren't you ashamed of what you do?" And I said, actually, no, I'm not, because I think that the role of the press is to keep the government honest. If everything worked exactly the way we would hope it would in an ideal world and the law was followed to the letter, there would be no need for journalists to be monitoring what the government is up to. But we know from a variety of revelations going back probably to the Revolutionary War that this is simply not the case. So, it's all very well to say that the intelligence community through various laws is given a variety of discretionary authority, but that is presuming that it's going to be operated legally and in good faith. The mosaic theory is something we've all heard a lot about. It's a very facially persuasive kind of theory, because it's this idea that you can't possibly understand what this little piece of information means in combination with other pieces of information and the dire consequences that will occur as a result of that, because you're an outsider and you don't know. As I said, journalists are outsiders by their very nature. That is the role they play. They keep the government honest, or they try to. So I'm not making light of the possible ramifications limitations of disclosures, but as I suggested before, the practice of mainstream news organizations have been in the past has been to try their best to vet what those consequences would be. And I think this is the cost of living in a society that has a free press.
That is an inspiring and appropriate note on which to end. Despite vigorous disagreement of these complicated issues, we've heard among all of our panelists some defense that journalists do have a distinctive role to play. They are important in evaluating the public interest, and although embattled, it's a profession that needs to be preserved. Please join me in thanking our panelists.
Thank you for a wonderful discussion. Special thanks to Jeff Rosen for coming out to moderate this panel and doing such a fabulous job, setting a great example for all moderators of future panels. And we'll take a 10-minute break. We'll start right at 10:15. Thank you so much.
Thank you. Nice to meet you. Well, that's where I teach and live now. I'm not from Minnesota. I ended up there. Oh, yes. Yeah.
You made one comment. The purpose of the class
Well, keeping the government honest by keeping the public informed. I was actually having this discussion in my meeting. Talking about it's slightly different context, but we were watching excerpts from this old movie called North Side 777. I don't know if you've seen it, but Jimmy Stewart plays a reporter who basically investigates a murder conviction because he's been told that the guy isn't the terrorist, shouldn't be connected to the crime. And I was asking my students about this idea of journalists simply getting the information, putting it out there, and saying, okay, public, now you know the information is out there, now you take the steps to clean up the problem, versus what happened in movies.
That's terrific. Oh, it's great. Congratulations. Yeah, I'm excited. I wondered.
The pardon pool, basically being the advocate for this guy.
Which is when
My students all thought that was just fun.
It's before lunch. Okay, great.
Do that. There's supposed to be information out there for public connected. So if I wasn't precisely saying that, that's really great.
why don't you just declare whistleblower status and do it? I know he was a consultant.
Yeah,
He was
well,
a contractor.
yeah.
Does he have any authority to vote?
I think he does, but I think again, I'm not his defender, but my sense is that his rationale, his pretext is, if I were to try to do that, I would have to be arrested immediately because I'm not going to get this whistleblower. Look at what happened to Brad. He's been in trouble with well, I don't know. And of course, I also think that Manning is the opposite. Manning is subject to so, whatever happened to Manning, good, bad, there's nothing really, I think, what's going to happen is and it wasn't even
I just want to visit with you. Be careful in the winter down there in Minnesota.
yeah, I'll do my best.
Oh, that is amazing. I have to say, that sounds good. Oh my God. You were just right? Yeah, we got to dinner with her guys too. I'm in a little bit of a constitutional between yesterday and today. That is just. And is this privacy kind of focus on constitutional some kind? Sure.
Yeah. Well, I'm excited to do that. I know Rick is on the board, and we do know he's okay. So, and he, I know, is interested. I mean, it's not a work close security officer, and he'll be at our meeting. So, if you want to help, we're all right? Yeah. What do we do to make this happen? So what would you want to see? Jointly sponsored by the I mean, between the contacts, right, I'm sure we could pop both speakers and so where would you want to hold it? Okay. What do you think? When? You want to tell me? You want to have a lunch? Like, come down and have a lunch? No, you don't have to have the answers, but, I think it's a great idea. Okay, let's do that. So we'll pursue this sort of data privacy stuff separately, and then I'll set up time with you. And Anita. So I work in the practice, and yeah, we cover health system now. I'm doing health systems up first, just scary than that. But yeah, and it's not just me. We have 2 other people who handle privacy issues, and then my boss at the office. And we most of what we do is practitioner and then right? And basically the risk assessments throughout the universities, where our privacy risks are, trainings, and those kinds of things. So that's sort of 90% of what we do. Definitely wanting to do discussion. That's what data privacy got started us doing. Or the university. It doesn't matter to me at all. I mean, I'm happy to staff either the law school or the university, or the powers that be want it done. Okay, that sounds great. All right, good, thank you. So let me know if any of this.
Yes, I could. Okay. Do you care where we sit? You can take any seat. We can play musical chairs, or we can.
Most recent Christian Bale movie.
Excellent.
Bad dual use. Are the mics on?
Mics are live, so.
Okay, we need to get started. Running a couple minutes late already. Just give people a chance to move in. Let's see. We're just waiting for our fourth panelist to Okay, please join me in welcoming the panel on medical ethics and dual use. I understand that some of the conversation may focus on other aspects of medical ethics and the tension between medical ethics and national security imperatives. Kevin Govern will be moderating the next panel. Kevin is a member of the board. I'll allow the moderators otherwise to introduce themselves, and we'll get started. Thank you.
Might help if I actually turn the microphone on, although I usually use a rather loud and booming voice. I'll try to not blow out anybody's eardrums today. But welcome all those who are here physically present. This is our first event where we are also live streaming. For those who are looking in, watching in around the world, welcome to you as well. And particular thanks and praise to Claire Finkelstein for her great leadership, Center for Ethics and Rule of Law, for Dean Fitz for making this possible, and for generous contributors, donors, friends of CERL. In particular, I'm very grateful, in fact, I'm humbled by the panel members that I have along with me today, where we're talking about medical ethics and the problem of dual use. As a lawyer, a former military lawyer, and presently a law professor, this is but a matter of amateur interest on my part, and a certain element of scholarship. However, we have some true subject matter experts that are here. I can't possibly oversell their qualifications, but what I'll do is give the briefest of introductions, starting from my far right and then drawing in. We have Dr. Harvey Rubin, who's professor of medicine at the Medical School, Department of Microbiology, Computer and Information Science, and the director for the Institute for Strategic Threat Analysis and Response, ISTAR. He is one of the world's foremost experts on the notion of dual use. In a few moments, we'll define that concept for you so we set the stage. Closer to me, Jonathan Marks, Associate Professor of Bioethics, Humanities, and Law at Penn State University, and the Director of Bioethics and Medical Humanities Program at University Park Campus. Again, an extraordinary intellect, great insights, profound scholarship that we have. And to my immediate left, I have my dear friend and mentor of many, many years, John Wynn. John Wynn is Professor of Business Law at the Harvey F. Byrd School of Business at Shenandoah University. He's also been an Associate Professor of Law at the United States Military Academy at West Point, where we had taught together. And I, in fact, was one of his pupils at the Judge Advocate General School of the United States Army, when it was still called that, many, many years ago. We have a number of interesting topics to talk about today, but in a nod to our many philosophers that we have amongst us and those who are tuning in, I thought I would quote from Francois Rabelais. I should have the governed francophone of the family, my son John, be able to read this to you in French, but I'll only read it to you in English. I think the ethos of our panel and of the subject we're going to talk about today is as follows: that knowledge without conscience is simply the ruin of the soul. So please keep that in mind. That may spur some questions as we talk about our subject today. Before we can even talk about dual use research, I think it's important for us to be able to define it. Typically, we think of dual use biological research, and in that context, it is often defined as follows: biological research with legitimate scientific purpose that may be misused to pose a biological threat to public health and or national security. But that is only part of the definition, only part of the considerations that pertain to dual use. Inasmuch as the Department of Health and Human Services National Science Advisory Board for Biosecurity, you'll hear the acronym NSABB quite often today. So National Science Advisory Board for Biosecurity. That is typically what their focus happens to be because, as the title implies, they're focused on biosecurity. But think also beyond the realm of research of biological science to other sciences as well. It could be engineering. It could be mathematics, physics, a variety of areas in which, at the same time, there's a duality. There's a fact that one and the same piece of scientific research sometimes has the potential to be used for bad as well as for good purposes. The E in our Center for Ethics and Rule of Law, is something that I hope that we will delve into in great detail today. It is an ethical dilemma, this aspect of dual use, because there's a possibility of promoting good in the context of also potentially causing harm. You might promote health and at the same time have the wherewithal for the killing of innocents. It is an ethical dilemma for the researcher because of the potential actions of others. Otherwise, innocuous, even beneficial research could be used for used by malevolent non-researchers who might steal dangerous biological agents or use of an original researcher's work. And at the end of the day, those who are representatives of the people are government. It's a dilemma for the government concerned because of the security of citizens as well as health. So that was a long wind-up in terms of some definitions. How should we define dual-use research? But what I'd ask for is for our panel members to opine, to reflect upon some of the practical examples of dual-use scholarship, research, and application that have transpired in the past and are ongoing today. I defer first to our learned co-panelist, Harvey Rubin, who's spoken and written often on this. Harvey, would you give us some insights, please?
Sure, thank you, Kevin. Let me just, in my tradition, pose the the answer with another question. Let me just ask you folks, if you had the ability to design a compound that you could sprinkle in everybody's water, unbeknownst to them, that within 2 weeks they would be completely immunocompromised, they would have no ability to fight off even the most benign infection, and you could do this surreptitiously, with not very much experience, not very much expertise, but you could do this. Would you go ahead and do that experiment? Would you make that compound? Why in the world? Who would make that compound? Who would not make that compound? Most of you would not make that compound. Well, those of you who would not make that compound just wiped out all of our advances in cancer chemotherapy. Congratulations. So let me give you another example. And I tell you this for a reason. The reason is that those are dual use of concern. So when I was on NSABB, that Kevin referred to, we were very careful to parse out this notion of dual use. Science can be used for good or for bad, but we also appended dual use of concern. And the real issue, the real drama in all of these conversations is what is of concern. And that's really what the scientific and the policy community has to grapple with. So another example, suppose avian flu arguably has a 60% mortality, even more so than smallpox. Suppose I could tell you now that avian flu in the natural form doesn't spread human to human. So if I coughed on Jonathan and I had avian flu, he wouldn't get it. He would get the seasonal flu, but he probably wouldn't get avian flu. It doesn't transmit human to human. But what if I were smart enough to make a form of avian flu that actually was transmissible by aerosol, human to human? Why would I do such an experiment? If I could find the mutations in the flu virus that allowed me to transmit it to all of you with a simple cough, scientists would, that's a really cool thing to do. Who would do that experiment? Who would not do that experiment? Most of you would not do that. Well, that was the most recent NSABB conundrum. I was on NSABB for the first 2 terms. I didn't have to vote on this last one. That experiment was actually done, funded by the National Institute of Health in 2 universities, one in Wisconsin, one in Holland. And that caused an enormous amount of debate. In fact, the scientists in Holland almost went to jail because of it. Why do that experiment? And there are a lot of these kinds of things because we believed that, in fact, it's good science, the motivation is right, and I'm using the words that were used in the panel before me. It really is striking. The same language that the journalists use, and I wrote it down, accountability, motivation, accuracy, vetting, that's what we do in the scientific realm as well. Exactly the same process. And we come up with the same question, should we publish this or not? And that's where the conundrum really lies. And so there are many, many examples. There's another one, and I'll just be brief. Suppose I can calculate exactly how much botulinum toxin I have to put in a container of milk to kill a certain number of people, and I can make that calculation. Should I publish that? It turns out that that was published in the Proceedings of the National Academy of Sciences. And so, these issues come up all the time. We all do research that is, by its very nature, dual use. The question is, what is dual use of concern? And we can spend enormous numbers of hours, which we did do at these committee meetings, to try and figure out what is of concern.
Jonathan, why don't you give us some insights as to some of the research that you're doing and some of the other matters that are being explored at Penn State and elsewhere?
So I'm probably not, it's great to be here, and thank you for that kind introduction. I think I'm not as deeply immersed in this topic as perhaps some of my panelists, fellow panelists, but let me just begin by saying that often when we talk about dual use, there's an assumption that we're talking about some nefarious other who will use this scientific development against us. And of course, the important thing to recognize is that, what we do when we conduct this kind of research is we create something which we too may be tempted to use, or those within our own society may be tempted to use. So I think that is important. The other thing, of course, is to recognize that there are, some legal constraints. So some questions were circulated amongst us as panelists in advance, and there was this question of prior restraint. So the first thing, of course, is to acknowledge that certain things are already prohibited by the Chemical Weapons Convention and the Biological Weapons Convention. So they provide the outer boundary, but of course what they do is they leave open the question of defensive and protective research. Now, one of the arguments that is often made to justify exercises like playing with various flu vaccines or smallpox or others is defensive. You know, so we need this in order to make sure that we know how to deal with it if somebody else should choose to use this against us. And one of the things that I'd just like to sort of, a little marker I'd like to put in the sand and perhaps hear from my fellow panelists about, is that it seems to me that the defensive argument almost proves too much. Because you can use that argument to just about justify anything. On the grounds that, well, we should do it first so that when somebody else does it, we're prepared. So I'd like to sort of put that marker in the sand and hear what my fellow panelists think about that.
Excellent. And actually, that's a fantastic segue to my brother by another mother, John Wynn, who in many instances was advising commanders, and in particular teaching not just the law of armed conflict, sometimes known as international humanitarian law, but also teaching professional ethics at West Point, for the impact on the military in particular. And now, when your president, guys, is a professor of business ethics, what are some of the end user considerations for these notions of defensive applications?
I'm here because of Kevin's genius for putting square pegs in round holes and somehow making them fit. So Kevin asked me, and I'm sure I'll be happy to do this, but I think Kevin wanted me to sort of look at the human dimension. And an area of my real interest is essentially accountability, which is what Harvey mentioned as well, and background investigations. In fact, if you don't mind, and bear with me, I went to a movie a few months ago with my teenage children, sons, and we went to go see the Christian Bale Batman movie, Batman and Beyond or something like that. It was okay, honestly, I don't want to offend anybody, it was a horrible movie. Because essentially the plot is, and I don't want to spoil it for anybody who hasn't seen it, although you can save some money. Christian Bale, as Bruce Wayne Foundation, they do this dual use technology. They create like this fusion reactor that's, it's maybe about 5 feet in diameter, round ball, and it's like, cheap energy fusion reactor, completely in the secret, made in secret by the Wayne Foundation, and no controls, no accountability, and then essentially bad guys get this thing apparently pretty easily, just busting a hole through some concrete, and then flipping a switch on this device to turn it into a hydrogen bomb, essentially. And so and then the hero of the movie is the guy who created this chimera, and foisted it upon the city, and then hundreds of people, I guess, got killed in the movie. I fell asleep, but essentially Batman saves the city by taking this device that he was responsible for, which after hundreds of people have died, billions and trillions of dollars worth of damage to the city, and he takes it out and it blows up, out in the Atlantic Ocean somewhere. So the question I had was, why is he the hero here? What happened to the accountability? This is the guy, he should be executed. This is death penalty stuff. To let this thing loose, to even create the thing to begin with. So I just love the fact that you mentioned the accountability. But, let's go back to reality a little bit. POC Bradley Manning, and this is not dual use, this is just sort of the security and aspect. POC Bradley Manning, it was insanity for this guy to have the access that he did. Ed Snowden, if you look at really I don't know how he got whatever discharge he got, but essentially our industry of outsourcing background investigations and security of these people who have access to this potentially in the future, obviously even now the dual use or now just intelligence, it's insanity. And even the guy who was at the Navy Yard, Aaron, I forget his name, that was insane. And so my question is that if we continue down the path of the dual use, whether it's in any particular field, where's the accountability? If we don't, none of the people who hired Snowden or allowed POC Manning to have access to the SCIF or let this guy on the Navy Yard and then just basically farmed out the responsibility to these contractors, there's no accountability. Nobody basically has taken the heat for the poor judgment that took place. And so that's my concern, is that when we sort of know we're heading down an area of known risks, that in fact, tremendous risk. If we don't have a sense of responsibility, even if it means creating additional bureaucracy and additional cost and all those things that we don't like about big government, it's something we really need to think about, and I don't think we've done a good job with that.
And especially since 9/11, John, you bring up a great point on accountability. Since 9/11, and in particular the anthrax scare, immediately after 9/11, all of us are witting of that. We all recall. And the so-called Amerithrax investigation at the FBI had concluded just 2 years ago, 2011, that Dr. Ivins at the U.S. Army Medical Research Facility at Fort Detrick, U.S. AMRID, had been doing research and had patents for new vaccines against anthrax. And at the same time, supposedly was the one who was weaponizing anthrax to be able to use to potentially infect hundreds, if not thousands, of individuals. So the dual use awareness has really spiked since 9/11. Love to be able to hear some more comments from our other brother panelists up front with regards to this, please.
So that's a nice combination of what Jonathan was asking about, defensive work in the context of offensive work. And I'm glad you reminded me about the Wayne Foundation. I'm going to have to write them a grant. I have a new way to fund my... So your comment about the anthrax attacks and Jonathan's notion of we say we're doing this because we need to have defensive capability. Well, that's exactly the context. So we do have a very robust program in making countermeasures. And for, complete disclosure, I have, grant money to do countermeasures against bugs that can, we call category A and B bacteria. So plague and anthrax and things like that. And so somebody could accuse me of being a bioterrorist because I'm working on antibiotics for some of these bugs. Simultaneously, I'm working on antibiotics that will kill you if you go into my hospital because we have this problem of antibiotic resistance around the world. That could be a potential bioterrorist agent. We have bacteria now for which we have no antibiotics. So I would say to you that, in fact, I am doing defensive work. But if I go overseas and I talk about this, you're exactly right. People will say, hey, Ruben, you're working on this not because you really care about defending or treating antibiotic-resistant bacteria or anthrax, but because you're really planning to attack me with it and you want to be protected. And that really does color a number of conversations on the international stage. We're American scientists. We're more well-funded than almost any other country. And there is a fair amount of distrust of American scientists, especially when you work in this area. I think the Amerithrax issue is a perfect example. How that was parsed out over the years that it took to really find out who in fact was responsible. And it's still an alleged, because unfortunately Dr. Ivins took his own life, and there was never really, I think, a satisfactory conclusion. I think all the evidence points in one direction, but it hasn't necessarily been proven. And what he was doing in his lab at Fort Detrick was known. I mean, there is certain classified information that he was working on. We can't do that at our university. What I do in my grants is completely open, and we publish everything. But I do say, yes, I'm working on in a defensive mode. But I'm defending us against the bacteria, I would say. I'm not defending us against somebody who potentially would use that bacteria. So again, it's motivation, it's all the conversation, and I am accountable. So at NSABB, we clearly put the onus on the principal investigator of the research program. So I am primarily accountable for what I do. The journal, my university is accountable for what I do. The journals to which I submit my paper is accountable for publishing it. If it comes to a point where somebody thinks that the accountability has not been adequately overseen, it can go to a place like NSABB or some other, or the World Health Organization or The Hague, or the government, who could say, no, we've funded this, we're not allowing you to publish it. So the same kinds of conversations that we had earlier in the day really apply here. But the accountability starts with the principal investigator. And I think we can legitimately say we do defense without doing offensive weapon development.
So there were several, I was visiting at Princeton in the wake of 9/11, and there were several days when I couldn't get my mail because of anthrax in the Princeton post office. So I was directly affected by that. On the question of accountability, it's just again important to note at the extreme level, so if you do have participation in the offensive, there are mechanisms of accountability. And in fact, a very long, drawn-out and ongoing mechanism was that we've seen in South Africa, the Health Professionals Council dealing with the complaint against Wouter Besson, who was a cardiologist that during the apartheid regime was in charge of Project Coast, the chemical and biological weapons program of the South African government, which had both offensive and defensive, right? So at the extreme end, that's one form of accountability. In fact, actually, he was prosecuted too, although those charges were not successful. So that's the extreme end. Then the question is, once you move in from the offensive to the defensive, what kind of accountability mechanisms do you have? But for me, it's important to move one stage back and think about how it is that we get into those situations in the first place. And what's really surprising, I think, is the work of Brian Rappert at the University of Exeter, who surveys biological scientists all across the globe in countries like Israel, Australia, the US, and Britain, among others. And, his work reveals how rarely biological scientists actually think about the potential harmful effects of their work. Clearly that doesn't apply to the members of the panel, but there are many biological scientists out there who, according to his work, don't think about it. And I think that thinking about the dual use concern issues should be part and parcel of a larger set of questions that biological scientists should address, which is the broader impacts of their work. The kind of questions they're now asked to consider in NSF grants. And I say this because when you ask many scientists what research ethics is all about, they're thinking about the responsible conduct of research. They're thinking about falsification, fabrication, plagiarism, and that sort of thing. But there are two other components of research ethics that are greatly neglected. One is the sort of values embedded in the research, and the other, which is more pertinent, is the one I've just identified, which is these broader questions of the broader impacts of the research. And I think if we had better ethics education for scientists and a richer discourse between the scientists, the ethicists, and the public, that would certainly help in addressing this problem.
Kevin, we are hoping to maybe allow more time for questions than we did in the last panel. When I cut Harvey off, why don't you finish on this topic, but then perhaps after that we could go to audience.
Excellent.
So Brian and Malcolm Dando and those guys, we know them very well. They're all over the place interviewing a whole bunch of scientists. The one thing we don't want to do, though, is impede innovation. And it's true that we always said it started with education, and that the notion of ethics really has to start even at the high school level, and the so-called do-it-yourselfers. Because biology now, you can order anything you want from eBay. You can buy all the DNA you want. And kids are doing it in high school. Kids are doing it in their backyard, in their garage. So where does this education start? It really starts even not at the university and the research level, but even in the high school. And we think that's all very, very important. What you don't want to do, though, is stifle innovation. And you don't want to put too many regulations in place where now I have to fill out 10,000 more forms in order to get my research proposal done. And there's a balance, and the nuclear scientists started this, after the bomb, and in terms of who's responsible and what should we do in terms of regulating ourselves. Biologists, I think, have been in the forefront of regulating themselves, in the sense of really having conferences and talking about these issues. Honestly speaking, and I can't speak for the entire biological community, I don't want to have a whole lot of oversight in what I do, because it just is an impediment to innovation. That being said, though, we have to be cognizant of the ethical implications. There's no question about it. There is ways to think about forbidden knowledge. Some of the work we do, maybe we shouldn't do. But that doesn't mean we shouldn't do all of it. This notion of knowledge that can cause great harm is not new. Odysseus had the same problem. He wanted to hear the song of the sirens. So what was his solution? His solution was actually partial knowledge. He stuffed the wax in his crew so they couldn't hear the song, and he instructed them to tie him to the mast so he couldn't get off the ship and go to the island. So his solution to this deadly knowledge was partial knowledge. And that's what came up in some of these avian flu papers. Should we just maybe not tell everybody what the sequences are that allow it to go human to human? That really does fly in the face of the notion of scientific openness. And many of us were uncomfortable with publishing a paper without full knowledge of the scientific achievement. And I think if we have too many preset notions of what's ethical and what's not ethical, we could lose the notion of scientific achievement.
Claire, would you like us to open up to the audience at this point for some questions on these very, very interesting and provocative topics? I think we have Joel Zacher, one of our board members and learned experts on non-proliferation, that has a question.
I'm going to ask a question. It's a little bit out of my league, but I'm going to ask it anyway. So there was a very interesting article. Okay, I'm sorry. There was a very interesting article in the New York Times, and the issue was, is there somehow an inherent gene or whatever in mankind to conduct warfare? And my question is, do you think there's an inherent gene in mankind to delve into knowledge that they know is going to possibly at some point in time destroy them?
Jonathan, you're our resident neuroscientist expert. Might you address that, please?
So I tend to push back against genetic determinism and neurodeterminism for a couple of reasons. One, I think it's a cop-out. Right? There's a moral hazard to saying, well, you know, we're driven by our genes to do this, or we're driven by our neuroanatomy or neuroarchitecture or neurochemistry or neurobiology to do this. I think we have an ethical responsibility. So it matters not whether genetics plays a factor in this. And I won't comment on that, I'm not a geneticist, but I think we do have an ethical responsibility. There are lots of things that we're more naturally inclined to do than others, but we have an ethical responsibility to try and work out what the right thing to do is or the best thing to do is. And I think that applies as much to this kind of research.
John, some thoughts on nature versus nurture, the inclination to kill. Often we looked at the book On Killing at West Point as being one of the required readings for cadets in looking at the psychology of soldiers in making, being prepared to be able to discern as to when life might be taken or life might be preserved.
Yeah, that's it's metaphysical stuff is sort of a little bit beyond me, but you know, we have the ability to destroy the world even now. I forget how many strategic nuclear weapons there used to be, 20, 40,000 ABMs or something like that, and we've reduced that and all that's good. But at least so far, we have not destroyed the world with the capability that we have with ballistic missiles and things of that type. So I don't know whether that is a metaphor or an equivalency, but I'm hopeful that is something that we can learn to live with, and that we really, we have no choice. We either live with it, or we basically kill ourselves with it.
And let's hope that this is not a foretelling of things to come, but there's a scientist by the name of Earl Brown, who's a researcher at the University of Ottawa, who said that if you gave him $100,000 in 2 months, he could recreate the 1918 influenza virus. As a matter of fact, scientists in Canada, no, don't get paranoid about Canada now. They are, in fact, working with the 1918 influenza virus, which was a pandemic. It had caused millions of people around the world to die. And this is a prime instance of dual use, of researching for the next pandemic by being able to look back at what had previously been experienced. So, fortunately, with self-restraint, with an internal code of ethics, researchers like those who are here at the panel and those elsewhere have self-constraint, but there's no internationally accepted norm of a code of ethics for dual-use research. There have been attempts at it, as our panelists can talk about, but there's no convention of ethics on bio dual use. Additional questions, please.
But by the way, that Spanish flu experiment was done and published.
Hi, everyone. My name is Candace Player. I'm a fellow here at the law school. So my question is, What security measures do we have in place to prevent the misuse of these agents, and how adequate are they, or maybe perhaps less naively, how inadequate are they? You mentioned partial knowledge as one of the solutions, but are there others?
Yeah, so one of the, a large measure of what we did on the last time I was on NSABB was look at personnel security. So the question is who works with these agents? And depending on where you are, there's various levels of security. And it turns out that in my lab, you come in, you have a good resume and you've published a few papers, and you're a hard worker, I'll hire you. I don't do any background check. At the corporate labs, they do it more, so if you work for Merck or somebody like that, they'll do a better background check. And if you work for a national lab, they'll do a complete background check. So the issue of personnel security is one that we haven't really resolved yet. There is no harmonized, if we had to do a background check and everybody who came to the lab at a university, science would stop at the university level. National labs are different. So in some sense, you're right. There's a big gaping hole. But even in the national lab, Ivans was in a national lab. And so there is this issue of ongoing security of personnel. And then there are various rules and regulations of what kinds of agents you actually work with. And if you work with a select agent, there's a tremendous level of security that you have to go through. So it depends on what you work with, and where you are in terms of your lab. So those are and some of these issues are not so much are we going to use it deliberately, but what about lab accidents? And so a lot of the issues come up not so much because I think we're going to use this to kill somebody, but people make mistakes in labs, and if something gets out by accident, that could even be more as devastating.
And mind you, we do have non-state actors. We have terrorists. Think back to the Aum Shinrikyo sect that was able to successfully create not a biological agent, but a chemical agent, sarin, killing dozens of individuals in Tokyo, Japan, and injuring hundreds. There had the Rajneeshi cult that poisoned over 2,000 people with a botulism toxin in the Dales, Oregon, by, don't get paranoid about the next time you go to a salad bar, by infecting salad bars with bacteria. So not everyone that is going to be accessing these agents has the scruples of a Harvey Rubin or a Jonathan Marks. We're going to have some non-state actors having some industries that might be tempted and transitions. We know that we're in the process now of non-proliferation with the chemical agents that Syria has. Well, an effective coalition is going to keep that under control, but to quote Yogi Berra, you only know what you know, or you don't know what you don't know. That's not a variation of what Rumsfeld had said, the unknowns.
And if I can follow up, let's go back to Fort Detrick. If Dr. Ivans was the person who basically released this agent, there were huge clues. Why are you spending, nights, weekends, evenings, who's watching this person? And so there's a supervisory responsibility, I think, that has to come with this type of research. And in that particular instance, this is a national top secret sort of program. And how is it that someone basically is allowed to get away with this level of laxity and informality in a scenario where you have that level of toxicity? So it's a tough one. And at the same time, you want to have openness in science, and you have that. It's not a balance. It's the more we know about science and the more we know about these things, the better.
Claire, I believe you've got another person in the audience with a question.
Actually, one of the reasons I wanted to leave more time for questions was so I could insert myself into the list as
Excellent.
a member of the audience. I'd actually like to ask a question that's off the topic of dual use for the moment, but a very important ethical question, which is how often, if ever, should doctors be involved in treating those who have gone through interrogation? This is a question that will also come up for mental health professionals, but I'd like to make sure that we are able to connect and compare across panels some of the issues that arise routinely. So maybe, Harvey, maybe you could tell us something about the conflicts that have arisen in this area, and then the panelists could answer this question.
So if I understand your question is treating patients who have been through interrogation or not. So my clinical practice is in infectious diseases, so I'm really confronted with this kind of issue. Our Hippocratic oath is that we take care of everybody who comes to our door without prejudice. So if anybody, and this is a classic medical ethical problem, if Hitler came to your clinic, and would you treat him or would you let him die? And so I think that the easy answer is that the primary responsibility for a physician is to take care of the patient that's sitting in front of you, no matter what, and then the consequences will play out afterwards. That's not to say that that physician has the same responsibility in creating conditions under which an individual can be interrogated the most successfully. That's a completely different story. So you gave me the easy question about treatment.
I meant to give you the hard question.
I was afraid of that.
What should doctors be involved in facilitating and assisting interrogation by being prepared to treat patients who have undergone it as part of a overall government program?
Right. So I can only answer for myself. I actually do believe in the Hippocratic Oath of above all do no harm. And I think that is the one thing we all remember from medical school. We don't remember the Krebs cycle and all that other stuff, but we remember that. And if somebody asked me, would I do that? The answer would be no. If somebody asked me, could I design a painless death penalty sort of cocktail that I could inject into somebody? My answer would be no. So that for me is a very simple question. The part about would I take care of patients if one of my colleagues did such a thing? The answer is of course yes. But people have different approaches.
Kevin, I'm sorry, go ahead.
So this is an issue that I know Greg Block and Steve Xenakis and Len Rubinstein are going to talk about in their panel. So the way you originally framed the question, it sounded a bit like the novel by Damon Galgut, The Good Doctor, but again set in apartheid South Africa, where a physician is called in by a general and there's a bleeding body on the floor, and the physician is asked by the general, will he make it through the night? And the physician looks at him and says, yeah, he should. And then he leaves, and of course, they carry on torturing him, which is clearly problematic. So that's how I understood the question as you had originally framed it. If you're a physician and you walk into a scene, or you're brought into a scene where somebody has been interrogated and abused in the process of interrogation, your job is to report. And there are clear protocols for reporting. So simply to treat and not report in order to facilitate ongoing interrogation would be problematic. And in that environment, it seems to me the physician is essentially the advocate for the detainee. I will say that what becomes challenging is when that physician also happens to wear a uniform, because, in order for there to be a relationship of trust between the patient, there has to be a relationship of trust between the patient and the physician. And if the patient is a detainee who's been abused by others in uniform, he may find it difficult to trust a physician in uniform, even if that physician is acting in the way I've described. I'll leave the other question, which is a fascinating one, and I will likely to interject on that panel about the use of health professionals in the design of aggressive interrogation strategies.
John, you had an insight you wanted to share.
Well, I didn't realize we're going to dive off into here, but this is almost exactly what Kevin and I were talking about as we walked over here, which is sort of a colleague who brought up sort of the dark side. And all I could come up with is that, from the legal perspective, there is a dark side, and sometimes you have to go there. But but we don't break the law. So there is aggressive interrogation, there's cruel and inhuman treatment, and there's torture. So the easy answer for me as a lawyer is, if it's aggressive interrogation, then I don't think any psychologist or psychiatrist who's involved in that, while they're in the military especially, who facilitates aggressive interrogation. And clearly there's a fine line going on here. Those people should not be disciplined, because at that point they're substituting their judgment at that point. But if there is cruel and inhuman treatment and torture, both illegal, then at that point I think the psychiatrist or psychologist or healthcare person, at that point there's an ethical problem and a legal problem as well.
There's another wrinkle in your question. This really has a tremendous impact and consequences. So there's the famous case of the doctor in Pakistan who was so-called presumably giving oral polio vaccine to people around Osama bin Laden's little hut. And in the meantime, he was taking swabs to track the DNA to see if he could find out what the family relationships were. That became known. The consequences in polio workers around the world has been just been tragic. What happened to the guy? He was in the pay of the CIA, from what I understand. It was the stupidest thing I had ever, that I'd ever seen. To have a physician, and in the guise of giving, and he was giving polio vaccines, but also taking DNA swabs. I mean, it's sort of a question, a related question. What was the rationale for that? What was the thinking behind that? In terms of trust for a physician, there is now no trust in polio workers around the world, in that part of the world, because of that one case. And did that guy actually abrogate his Hippocratic oath?
Additional question up front. I'm sorry, to our right, wherever the microphone goes first.
Hi, George Brankert. I heard a couple rationales for the kind of dual use that you've been talking about that might have horrific second dual uses. One was the importance of innovation. The second was defensive. So my question is, if the defensive rationale is an important part of it, if a researcher is engaged in creating a product that has dual uses, should they make that product known or publish information about it before they have the defensive response to it? In other words, just not put it out there. We're doing it because we want this defensive, but they haven't developed the defensive. So do they have a responsibility not to do that?
Then I'll answer. I think you raise an important question. The way people tend to frame the defensive is we're doing it with the intention of creating a body of defensive research. Of course, the thing is that when you publish research, you publish it for replication and verification, right? And that creates, in my view, a real concern, because this is the kind of thing that ideally you don't want replicated. So, my concern is that we have gone to, I'm not necessarily proposing multiple additional layers of regulation that Harvey was concerned about, but I am concerned that the default leans too closely towards publication rather than away from publication, and too much toward doing the research and not enough second thought about the research. So what tends to happen, I think, is there's a lot of agonizing and sometimes presenting before the NSABB, and then it goes ahead. And I think, maybe we need a little bit of a heavier presumption the other way, because it seems to me that the default has become to do and to publish. And I have some concerns about that.
So in every grant that we write, and just about every introduction to every paper you write a significance part. And so if the significance of doing this research is because you recognize there are serious issues that need to be confronted, so antibiotic resistance or vaccines that no longer work or immunosuppression, if you're doing the research and you can contextualize it, the word we heard earlier this morning, then that really becomes very important. If what you're doing is the only context for which you're doing something is to protect your warfare, your war fighters in case something is lobbed at them, that would be very hard to justify in terms of university type research. Now, I'm sure it goes on in national labs, but the kind of work that we do here at Penn and presumably in corporate pharmaceutical labs, it's generally because there's a perceived need, an unmet medical need, not an unmet national defense need. But there are places where that's done, in places like Fort Detrick.
Additional questions?
Hi, my name's Alex Turner. I'm a criminal defense attorney here in Philadelphia, and I have a science question. We've talked about two parties in terms of the typical biological research where you're manipulating the genetics of a virus to try to maybe make it a more potent virus or something that's worthy of research. We talked about the good scientist and the bad scientist. The good scientist who wants to help and maybe is taking a defensive posture, the bad scientist who wants to weaponize it. And it occurs to me that there's actually a third party out there who is also manipulating the genetics of viruses, and that's natural selection. And natural selection actually has a much better track record of killing people than bad scientists. What I don't understand is, you take the avian flu, the likelihood, is it just a matter of time? Is it 1 million years? Is it 10 years? The likelihood that it's going to mutate into a form that can be transmitted. And how do we predict that? How do we weigh that? How do we consider that? In taking a defensive posture, not necessarily towards other people, but towards what might happen. And in some cases, it's preposterous. I mean, I'll quote Jurassic Park, nature finds a way. Nature's not going to bring back dinosaurs. But how do we weigh that? How do we consider that?
So you're a very well-educated lawyer. My wife, who's a lawyer, could never ask that kind of question. So let me give you the science behind the answer to that question. So what Ron Fouché and Kurosawa did is actually deliberately try to find mutations in the hemagglutinin gene protein that allows for human-to-human or aerosol transmission. And they found 5 mutations that allowed the avian flu to become aerosolized and transmitted. The argument against publishing that work was that it's not clear that nature would have converged on those same 5 mutations. And so what everybody was saying was that all you've done is tell a terrorist on how to do it deliberately. And if you think you're going to use that information to screen, the argument by the scientist was, now that we know what mutations have to appear to make this transmissible, we can tell the public health sector, look for the emergence of these mutations, because that means avian flu is now moving in the direction by natural selection to become more transmissible. The argument against that was, you don't know that nature is going to even converge on those same 5 mutations. It turns out that we're still learning. It's not hundreds of years. It's probably because of the way avian flu replicates. You can easily get that within a few generations. And so it's not clear, though, that nature will converge on those 5 mutations. Fouché said in many meetings that we were in together at the NIH and The Hague, we have to know at least these 5, because if we do see that, it's an important public health initiative to start hunting it down. But it's not hundreds of years. It's short, much, much shorter for that particular virus because of its recombination ability. It's a great question, though.
I believe we've got our next question from Ambassador Del Daly. Sir?
The medical professional has gone through the dual-use challenge, has concluded that they disagree with producing or publishing or releasing. What do you view as their ethical responsibility at that point? Do they just back out, or do they aggressively subvert what's taking place because in their mind they think this is going to go the wrong direction?
I'm not sure I understand the question. What would back out in what sense and at what stage?
Just refuse to participate and say, okay, I'm not going to work on this project anymore, or I quit, or whatever. That's the benign one. Or the aggressive one saying they're going to take some type of action to subvert the success of the process or of the publication of the information.
Well, the other issue, of course, is speaking out, right? So if you decide to step aside from a project for ethical reasons, but the project is ongoing, and you think the project raises fundamental questions, then there's a sort of related whistleblowing question, which is also somewhat discussed in the medical ethics literature. I'm not sure if that's what you intended, but it strikes me that if your question is, should a health professional who finds him or herself involved in a project that they think raises ethical issues, is it enough for them just to step down, or should they do more? Which sort of leads us back to the question on the first panel. But I think there are real questions about whistleblowing responsibilities. If what is going ahead in the view of that health professional is fundamentally problematic.
But the other side of the coin, though, is what if you think that the work is that important that you really want to continue working on it, and yet NSABB, the World Health Organization, in your own country says you can't do that? Do you continue working on it? Do you publish it just the way you do a WikiLeaks? You don't need to publish in Nature, Science, and Cell. You could put it out on the internet and it's there. Nobody can stop you from doing that. It turns out that we have these things called, at least the Dutch said, we have these things called export control laws. And that, in fact, they were going to fine Ron Fouché like $500,000 and put him in jail if he were to go ahead with the work that he was working on avian flu. He successfully appealed that. So the notion of pulling out and not saying anything, pulling out and being a whistleblower, but the other side of the coin is this is my life's work. I'm going to continue working on it. I don't care what you say. I have my lab and I have the ability to get my information out there. Then you're subject to the laws of the land. And that became a real issue for this particular Dutch scientist. And, you know, he said that he had the courage of his convictions and he was going to go forward with it. And fortunately for him, the Dutch government backed off.
And Harvey, in your view, did that case come out the right way?
Yes. Yes.
Hi, I'm Govind Prasad from the Department of Medical Ethics at Penn. I was interested in Harvey Rubin's comment about worries about there being too much oversight of research, because it seems to me in dual use research, I wonder whether it actually would make sense to have someone consider broader social impacts, to have democratic oversight of those social impacts. So if you look at other professions like finance, people say, well, it's important to have self-regulation so we get a lot of innovation. One concern is that you get innovation that's not necessarily socially productive innovation. Right now, IRBs aren't permitted to consider broader social impacts, although a lot of people argue they do anyway. But we have historically, for instance, in human gene transfer research advisory committees that do look at those specific areas of research. So I'm curious for the panel generally, whether you think there is room to have broader democratic oversight of the social impacts of this research, and if you have thoughts about ways that this could be done while minimizing these worries about burdens on innovation.
I'll let my colleagues answer that because you know my feeling, but go ahead.
Well, there's certainly been attempts at that. The meeting of states parties to the Biological Weapons Convention tried to develop some ethical codes. And that's certainly significant to have peers, not do peer censorship, but peer awareness of these issues. Inter-Academy panel on international issues, similarly. A number of learned scholars who've, dare I use this metaphor, taken a stab. They've made an attempt to be able to create codes of ethics. Perhaps to act locally, but think globally. In the individual laboratory, to be able to have an ethos, having strong leadership of best practices. That pertains really in any business, but also in particular to the business of science, to the extent that I understand it, appreciate it, and have viewed it. But I go back to my point that I made several minutes ago. There is no international convention on ethics for biological research. There's no international convention for the ethics of the use of these other things that have been described in treaties, the 25 Geneva Convention, the 72 Biological Weapons Convention, and onward. These are proscriptions that exist, yet there's still an ethical component which is not necessarily proscribed by what exists there. So I would exhort you, as you're working with others in the field, and as you go off to industry, to research, to wherever your destiny may take you, to bring along that sense of ethics and to expand it. Not sure that there's a one-size-fits-all solution in terms of having an overarching ethical code.
So one thought I'd like to share, and it's interesting that nobody's raised it before, is that I'm at an institution which has an applied research labs that do work on non-lethal weapons. I have no idea beyond documents obtained from Freedom of Information Act requests. I don't know the details of what goes on. I can't find out because I have no security clearance, so I can't walk through the front door of the building. But I do think, that we have my institution, and this would apply to others too, my institution, those of us who are members of it, have an obligation to try and pose this question: is this what a public university with a land grant mission, is this work we should be doing? And I don't think those kind of conversations and deliberations happen enough, and I hope that my institution is, Faculty Senate is now pushing for a much more shared governance model, and I don't know whether something will come of this, but one would hope that these are the kinds of questions that we would deliberate as a community, which right now the community takes no part in. So I think that's an important next step.
Do we have time for one more question, moderator?
Absolutely.
All right. There's a gentleman over here who's been waiting patiently.
Thank you very much.
Hi, my name is Joshua DeGastine with the John Jay Institute here in Philadelphia. But recently I come from Emory University, where I worked in the Rollins School of Public Health, which if you take a step outside, there's a fence, and we're directly separated from the Centers for Disease Control and Prevention. We were doing research in a toxicology lab. Last year published a paper on a high throughput toxicology screen where we weren't looking at, how much botulinum toxin does it take to kill X number of people, but rather how much pesticides does it take to give Parkinson's disease to X number of people. So my question boils down to, what is the appropriate level of separation there? Are you aware of any deficiencies in CDC policy as far as how much research they should be doing on that kind of dual use technology as opposed to their university partners?
Well, it really goes to what Jonathan was saying. We can't take, at Penn, we can't take classified, we can't do classified research as part of what we do here. We can do it a day a week somewhere else, but we can't do it here. The national labs, including the CDC, has a much broader mission than we do. And again, it goes to accountability and context. If that's an important question in pesticides, we use pesticides a lot, and I think we need to get that kind of information. And it's clear that there is a certain boundary that certain universities have staked out, and we're one of them, and we don't do classified research. Some of this has to be done, and we've not talked too much about national security. There's this notion of public health, the securitizing public health. And that is, when does an issue of public health become an issue of national security? And what you're talking about is a perfect example of that. There are arguments for securitizing public health. Michelle Obama says obesity is a matter of national security, too fat to fight, right? We've been saying for a long time that, AIDS, malaria, tuberculosis, highly resistant organisms, that's an issue of national security. But once you make issues of public health issues of national security, the level of conversation changes dramatically. So it's not me talking to my colleague in the Public Health Institute in China. It's the Department of Defense talking to their Department of Defense. And that changes the conversation. So the answer to your question has enormous ramifications that I don't know that I'm the right person to really respond to, but that's what you have to look at. You have to look at what is the issue if you make that an issue of national security. How does that change the conversation? And, I think certainly in terms of pesticides, there's a long history of having to know the answer to that question. So I would say I would be happy to do that kind of experiment in a university. But you have to be careful on how that's sort of put out to the public. It's a great question.
Ladies and gentlemen, we come not to the end of this conversation, but actually to a beginning of those who are around the world who are webbing in, as well as those who are physically here, for us to continue this dialogue on what's truly been a fascinating topic, and which will actually, as you will appreciate at the end of the day, will dovetail nicely with a number of the things that we've talked about. I thank each and every one of the panel members, and for all of you for your great questions and insights, and again, a great tribute to Claire of bringing us all together for this conference. I believe at this point...
And thanks to you, Kevin, for a great panel. We will reconvene at 11:30 for government lawyers.
Thank you very much. Pleasure to meet you. Nice to meet you. Great work. Pleasure to meet you. Thank you very much.
Dodged the bullet.
That's interesting. We should just take this. Penn State?
Yes, I am.
I know they apply physics like that.
Yeah, I would sometimes love to meet it if you were the conference. Let me ask you this. Almost over did you get an No, it worked out perfect. We were just having a question. I was interviewing the first anthrax vaccine, and you were telling me the box was never shot reference. Well, we didn't.
Could you have said that?
I could have at this point.
I wish you had.
So,
If I had known, I wish we had talked about that.
EMS from the Naval Army department. He's a Gulf War vet. So 4 of us were here where, in effect, it was untested vaccine.
Oh, if I, that would have been the perfect question. Is that ethics? You know what's the response?
Yes, he's professor of science. Right, Colonel. I chatted with him. The Marine, the khakis.
Yeah, I'd like to, or maybe Kevin, you can do that, like at one
I really interested in just retired out of Mars.
Had a chance to meet him.
Yeah. Now he's a Harvard fellow.
Can you introduce?
Yeah. Let me go introduce you guys.
One because you're a bad dude. He got secrets because of physical security. That's not because of business. That opened the door for information. That was his then to give him that level of non-compartmentalized information. I'd have done that. This is oh my God. Or like Air Force bases, Korea, and 24th they made a career fire attack, didn't fire. We had we don't have that anymore. So, it's better. I don't know. I would say it's better because it's less proliferated. You see how the German scapegoat. Brilliant books. One is bringing that back a little bit. The CIA has been Maybe. But this guy.
I've just published on this.
Angling for academia, or is this just kind of something you're doing for fun?
Honestly, this is an article idea that just sort of came to me, and it had to be written.
That's perfect.
That was exact. No, I wrote it in about 4 weeks, and revised it significantly afterwards. But just the idea that this has to be out there, and I was shocked that no one else had written it.
People ask me, I'm doing a lot of teaching, and how do I know if it's the right thing for me? I always say it's a variation on that. If there's something that occurs to you, you can't help writing it.
You can't not write it. Yeah. Yeah, no, it was a week. It was a month. We were extremely busy at work, and I just went home every night. I'm banging out 500 words. I don't care. But right now I'm looking at fellowships. I'm thinking about just sort of generally leaving my options open. The employment market isn't great. I'll leave my current position for about 6 more months. So.
No, the employment market is not great.
If people will take their seats, we should be ready to begin in a minute.
Really?
Do we have 2 additional panelists in the house?
Put my name in. The meat market's coming up. Wow. Maybe one more chair, yeah?
I will be giving a formal introduction to David Luban, our keynote speaker, later today before his talk. But let me just say one brief word about this panel, which is that this panel on the ethics of government lawyers has a kind of special meaning for CERL. One of the reasons I got very interested in the sorts of issues that we're talking about today was because of the example of government lawyers and thinking about the ethical obligations of lawyers. It's, of course, fitting that in law school we should spend a considerable amount of time thinking about the obligations of lawyers in different settings. And I think to many of us, we feel a special responsibility to do so. We are educating students in the ethics of their profession, hopefully. And I came to feel as I spoke to many individuals in the military, particular military lawyers, that there was in some sense a better appreciation of rule of law values in the military than there was among civilian lawyers. So this panel was really sort of the core, contains the core set of issues that generated the inspiration for the Center for Ethics and the Rule of Law to begin with. So I'm delighted that David Luban will be moderating the panel, and want to leave a good 20-25 minutes for discussion with the audience. So thank you.
I'm really delighted to be here, and I'd like to thank Claire and the staff for organizing this, I think, quite extraordinary conference. And I feel like this is a very extraordinary panel as well. I'd like to introduce the panelists. At the far end of Brad Wendell is a professor of law at Cornell and one of the distinguished legal ethics scholars and theoreticians in the country. His book on lawyers' ethics and fidelity to the law should be, I think, required reading for everybody who has an interest in legal ethics. Catherine Gibson, a legal advisor to the U.S.-Iran Claims Tribunal, and I learned that being legal advisor does not mean that she is an employee of the U.S., and I gather she's not an employee of the Iranians either, but the tribunal is funded by both governments. And she has written about the special ethical role of lawyers who are representing a national government in an international tribunal setting. Marty Lederman is my colleague at Georgetown Law, and he has also served in the Department of Justice's Office of Legal Counsel twice. Once during the Clinton and early George W. Bush years, and then as the number 2 in the Office of Legal Counsel for several years in the Obama administration. And he's also, I think, unquestionably the world's most prolific legal blogger. Although, yeah, I mean, the competition is extremely stiff. Alberto.
David's being modest. We just started a new legal blog that David's posts on have been well worth reading on many different interesting.
Thank you. And Alberto Mora was General Counsel of the Navy from 2001 to 2006. He has just retired as the General Counsel of Mars Industries and will be a fellow at the Advanced Leadership Institute at Harvard next year, and played an utterly extraordinary role in his time at General Counsel, as General Counsel of the Navy, in the formulation of U.S. interrogation and torture policy. And I'm actually this thrilled to be sitting at the same panel as him. I'd like to start with just a very simple question about what the difference is between a lawyer in government service and a lawyer in private practice. I mean, let's say, for example, a lawyer who is a tax lawyer, and there's a body of ethics doctrine about what tax lawyers can and can't do in our never-ending war against the IRS to minimize our liability, and some of it's very quantitative, that, for example, you can take a position on behalf of your client if you think that you have a 30% chance of prevailing. And we know that there's an ethics of zealous advocacy for lawyers in private practice. We know that the famous corporate lawyer Hugh Root over a century ago said a lawyer's job is not tell the client what to do, it's to, if the client says what he wants to do, you don't say no. Your job is to get him to do what he wants, or let him do what he wants to do, and figure out a way for him to do what he wants to do. Root also said that half the practice of a good lawyer consists of telling clients that they're damn fools and they ought to stop. These things are very hard to reconcile with each other, but let me just start by asking what the difference is between a government lawyer's duty of faithfulness to the law and a private lawyer's duty of faithfulness to the law. And I'll actually start with Brad, who's written a book on fidelity to the law.
Well, thanks, David. People may disagree with me on this, and particularly Marty, and I want to hear from him. But I actually would take an orthogonal distinction to the one that David suggests. So David suggests the distinction between private lawyers and government lawyers. I think the most important distinction is exactly orthogonal to that, and that's between lawyers appearing in a litigation capacity and lawyers serving as advisors. There is nothing that makes me more crazy and more apt to go off on a rant than hearing the duties of lawyers described as zealous advocacy within the bounds of the law when lawyers aren't serving as advocates. And there's a reason for this. And a lot of the themes from the earlier panels are going to come up again in this panel, I think. And two of the themes are trust and accountability. Right. One of the virtues of the rule of law is that it is what we have when we don't trust decision makers. The law is what constrains the power of decision makers, and it constrains individuals from doing what they take to be the right thing to do. The law stands in for what we as a community think the right thing to do. And accountability in a complex society as ours is an institutional matter, involving a lot of coordinate institutions that work together, and sometimes in a kind of conflict to ensure that, for example, the rule of law is complied with. And in a litigation setting, a lawyer is free to advance not frivolous, but perhaps sometimes aggressive interpretations of the law, because there's an institutional setting that allows for that. There's opposing counsel, there are judges, there are law clerks, there's briefing, there are appellate tribunals. There are all sorts of institutional mechanisms to ensure, in the end of the day, the law gets worked out in the right way. When lawyers are appearing in an advisory capacity, however, those institutional checking mechanisms are absent. And this is perfectly unexceptional in all kinds of lawyering contexts. And people who do what I do, who do a lot of professional responsibility work, do a lot of legal advising. I consult with clients, and I give them advice about what the law requires, and I give opinions. And I say the transaction you want to enter into is fine. And you know what? That advice is never going to get reviewed. It's in effect private. And a lawyer acting in an advisory capacity is essentially a private lawgiver to a client. And the obligation of fidelity to law flows from that, flows from the fact that the lawyer is the only accountable institutional decision maker standing between the client and the law. And if the lawyer doesn't believe herself to have an ethical obligation to interpret the law in good faith, then the law simply disappears as a constraint. And that's the source of the obligation, and that's true government lawyers as well as private lawyers equally.
Now, Marty, you, I know, said that lawyers in the executive branch, there's also a constitutional dimension to that. And I'm wondering if you could talk about that a bit.
I would like to, at some point we should transition to the question you started talking about, and Catherine has something to say about this, whether in litigation, as advocates, whether government lawyers actually have a different responsibility than private lawyers do, particularly in the federal government. I want to put that on hold, make sure we get to that, because I think it's a really interesting question. So David, just in terms of the U.S. executive branch, there's a lot of different government lawyers. There's state lawyers, there's local lawyers, there's lawyers for other nations. But within the executive branch, obviously there are many, many different types of lawyers. Within the Department of Defense, how many are there? 20,000 lawyers? Something. It's the largest law firm in the United States, is the Department of Defense. There's a lot of different kinds of law that are provided to the president and to appointees and to independent agencies within the executive branch. Brad, I think I'm going to disappoint you here because I don't think I disagreed with the word you said. I do think that lawyers giving advice to the executive about what the executive is legally entitled to do for the fact, as opposed to the litigators, are subject to a higher standard than the equivalent in the private sector. I'm not sure whether that comes from state ethics rules. David and I have had exchanges about this, whether state law ethics rules really were designed for this form of ethics, of legal advice giving, in part because the executive is also the prosecuting entity, right? It is very unlikely. The vast majority of advice given in the executive branch is going to, with respect to things that courts will never consider, either because they're not justiciable at all, or because if the answer is yes and the executive goes ahead and does the thing that it proposes to do, the executive is not going to prosecute the executive actors who relied upon that legal advice. And so, unlike in the private sector, where your advice is, at least in part, here are the risks that you will get in trouble if you take this route, if you take that route, and et cetera. Here, you're basically the last word, or in our system, the president is the last word, or the attorney general, but 99% of the time, for instance, the Office of Legal Counsel, or it doesn't come to OLC, the general counsel of an agency, will be the last word on what the parameters are. And the way I always saw my role, and I think this is true of, I hope, most of the lawyers in the Office of Legal Counsel, is, this is pretty abstract. The president has a constitutional duty to take care that the laws are faithfully executed. There's a lot of, obviously, historical contestation about what that means, what is faithful, how capacious are the laws, how much discretion do the laws give to the president. But our job, and I thought it was a very solemn one, and a real privilege to get up in the morning, is to help the president take care that the laws are faithfully executed. That's a pretty humbling charge, I think, and one that weighs upon you every day. And so I don't know how different that is than what the private lawyer does in advising a client. I think that it seems to be a little bit different and weightier in some respect. But I'm sorry, I don't really have any truck with what you were saying. But
would you like to jump in on this, Albert?
As twice a general counsel in federal agencies, I'll tell you two ways that it in my mind, it differs. The first is that in the private sector, you're authorized to do anything unless prohibited by law. In government, it's exactly the reverse. You're not permitted to do anything unless it's authorized, expected by law. So the sense of limitation going in to everything you do, the need to find an anchor or foundation in express authorization is something that alters the way that government attorneys look at their job. The other difference is that when I was in government, I always felt that government service and the purpose of a federal agency was always had a public trust element to it. So you have the client being in my case, the Secretary of the Navy, but the Navy ultimately, as every other federal agency, operates for the public good in a certain way, and everything that the agency did had to be reviewed through that kind of filter. Another kind of important distinction between the way I always felt as a private attorney representing a private client.
Now, Kate, are there parallel issues that come up in the context of a lawyer who is an advisor to a government going into an international law setting? And we all know that the United States on a number of issues has views about what international law is that are very different from the majority of states in the world. And
that's true. I think, well, just to add one point on the last issue we were discussing, I think a government lawyer, maybe more than a private practice lawyer, always has to think about what their relationship is to a particular issue and to a particular client. Even issues that would never reach a court might be in some sort of interagency process, so that a lawyer working for, say, the Defense Department can be very zealous, conceivably, in defending DoD policies if they know they're going into a meeting with state, with justice, with other agencies that might potentially counterbalance that. So I think a government lawyer has to be, even within the advisory capacity, when the primary role is going to be this sort of public service Minister of Justice role that I would feel very strongly about. There are times when you can, when that changes a little bit in the advisory role. In the international sphere, I feel like I'm sort of the resident frou-frou European in a way, and when I go to European meetings, I feel like I'm the American gunslinger, so I don't really fit in either world. But there are a lot of American views on international law that other countries do not share, and if you're voted in international law, that means that your view of the law is just wrong. So I think going to international spheres, the United States needs to be conscious of its role of just having sort of one vote in this, and it's an important vote. And the United States vote certainly carries a lot more weight than some other places, but the U.S. needs to be maybe a little bit more persuasive in reaching some of these positions than sort of just going it alone all the time.
Okay. What about when the client? You know what the client wants, and you don't think that the very best legal argument supports it. And you're a government lawyer who's giving advice to the client. And the client's question is, can you support what I want? And your view is you could support it, but that's not the best view of the law. Let me give a real-life example that is removed from U.S. practice, although the U.S. is directly involved, but that might give us something to focus on. On the eve of the Iraq War in 2003, Tony Blair asked his Attorney General, Lord Goldsmith, for a legal opinion about whether it would be lawful for the UK to participate in the Iraq War, for the war to be launched without going back to the United Nations for another Security Council resolution. And Lord Goldsmith wrote a lengthy confidential opinion saying that the best legal answer is go back. But that saying that you don't need to go back is a defensible position, but cautioned against it. And the next day the war was launched. I mean, I won't comment on the sincerity of Tony Blair's request for a legal opinion given the timing. Lord Goldsmith then had to go to Parliament to justify it, and he gave an opinion justifying it in which all of his caution were deleted. Now, eventually, the confidential opinion was leaked, and he was called back to Parliament and said, "Did you lie to us when you said that the law is all on your client's side?" And he said, "Of course I didn't lie to you," and it was a minor scandal. What do we think about that approach? What Goldsmith did. I mean, if your client says, "Give me the best argument that you can, and I get to do what I want to do," does a government lawyer have to answer the question in just those terms?
Let me take a first shot at this. It's a great question. We tried in the Office of Legal Counsel. I can't guarantee that no legal counsel has done differently, but when a client agency or the White House would ask us, we don't want to know what the best answer is. We just want to know whether there's an arguable, whether this will pass muster in court, or whether there's a reasonable argument, or whether, there's a 30% argument. We would resist the question before the fact. And David, you've raised the important distinction between what the lawyer does before the conduct is undertaken and what the lawyer does after the conduct is undertaken when it's trying to be defended in some other tribunal, whether it be a court, parliament, or anywhere else. And that's obviously going to be a different function. So in mid-2010, we in the Office of Legal Counsel published, you can find it online, principles for best practices for OLC legal advice and written opinions that says fairly straightforwardly, we must provide our advice based on our best understanding of what the law requires, not simply an advocate's defense of contemplated action. OLC seeks to provide an accurate and honest appraisal of applicable law, even if it will constrain the agency or administration's pursuit of desired practices or policy objectives, which is critically important to the office's effective performance of its assigned role. But we then go on to, not as though we're judges, right? It is different because the president or the attorney general or the secretary of agriculture wants to accomplish something. And so we go on to say that analysis may reflect the fact that our responsibilities also include facilitating the work of the executive branch and the objectives of the president consistent with law. And therefore, unlike a court, OLC will, where possible and appropriate, seek to recommend lawful alternatives to executive branch proposals that where the original proposals were unlawful. You try to provide a lawful alternative, but notwithstanding that, your legal analysis should always be principled, forthright, and as thorough as time permits, and not designed to advance the policy preferences of the president. So there is this dual role even before the action is undertaken. No, you can't do everything you want to do. The law prohibits that, but we're going to be sort of creative in-house lawyers helping you achieve as much as you can within the law. And then the role changes very differently, and it's a different lawyer's role to represent in court once the decision is made how to act. It's interesting to me, the Office of the Solicitor General, there will often be really knockdown, drag-out debates, with a lot of different lawyers throughout the government on what position is the right position for the United States to take before the Supreme Court. And the SG will, there'll be some cases where it's 51-49. And the SG finally decides, okay, I'm going this way rather than that way. Well, the brief doesn't read as though the question's 51-49. The brief reads as though here's the best possible argument in favor of the 51. And that's the question I hope we get into later in the hour with Kate, whether that's appropriate for government. It's clearly what private lawyers do.
Alberto, you found yourself in the position of having to push back hard within your own agency, and I'm wondering if you could talk about that a bit. And I think this is very much related to the question about Lord Goldsmith, who for a while, he was clearly on the team, but he was putting on the brakes, and then he wasn't putting on the brakes. And how did you, maybe you could just tell us a bit about that experience.
David, this is a long story, so I'll try to give you just a couple of the headlines. And what David's referring to is my involvement once I was informed of the rumor that detainees in Guantanamo were being abused by military interrogators in Guantanamo. And this was brought to me by the Naval Criminal Investigative Service, which I oversaw as part of my duties as General Counsel of the Department of the Navy. They were not involved directly in the interrogations, but they had learned from friends in the mess halls and the gyms and the barracks in Guantanamo that in fact, the course of interrogation that seemed to be creeping upwards into the realm of abuse and possibly cruel, inhuman, and degrading treatment, and NCIS felt would reach the levels of torture unless somebody stepped in and stopped this. Once I heard this, although this was not any of my responsibilities because it's not the role of the military department to be operational. So the Secretary of the Navy did not have any responsibility for interrogation practices in Guantanamo, and actually neither did the General Counsel, his General Counsel. But I felt I had an obligation to investigate if there was a bona fide allegation of potential illegality in Guantanamo. I was determined to try to stop it if that was the case and protect, give the correct legal advice, protect those engaged both on the receiving end and on the giving end of unlawful activity. David, why the question is complex is because my knowledge and what I thought the problem was changed during the months and years of my involvement. I found out within 2 days that the interrogations were being conducted pursuant to the express written authority of the Secretary of Defense, Don Rumsfeld, as communicated down the chain of command via Southcom and then to the commanders. And when I saw the legal memoranda which underlay Rumsfeld's authorization to apply these enhanced interrogation techniques, I thought it was a simple mistake. It never crossed my mind that in fact there had been a deliberate act of anybody in the chain of command, and particularly the attorneys, to authorize conduct that on the face of the documents was not limited to cruel and inhuman or degrading treatment, or even to torture. The document authorizing the interrogation techniques was unconstrained, and upon reading it, you could see that the application of any one of the techniques or them collectively could reach the level of torture. I thought initially that my obligation was simply to point out a simple mistake. The attorneys involved had made a mistake of legal analysis and legal advice, and then the Secretary of Defense, as those military officers, non-lawyer military officers who had sought the advice, made a mistake in not failing to understand or imagine fully the consequences of their decision. Later on, as we learned, this was I would learn very quickly, this was not still a mistake, but it was not inadvertent. That in fact, people were specifically attempting to apply these techniques and even harsher techniques to individuals, and this problem was not limited to the chain of command I saw, meaning Guantanamo up to the Pentagon. In fact, it was much broader, because it had the involvement of the Department of Justice, the Attorney General, White House Legal Counsel, OLC, Vice President, and the President directly were all engaged ultimately in authorizing expressly the application of these procedures. So my role during all of these subsequent understandings would change during time. But I don't want to monopolize. I could go on and on this issue.
I would like to know what, in particular, once you discovered all of this, and you find that you are, in a sense, bucking the entire chain of command of the United States government, how do you do that? How do you think about it? How do you view the ethical obligations?
I through layers. First of all, I thought it was an obligation to point out a mistake. I was going to give the DoD General Counsel the opportunity to correct this mistake. When he didn't seize that opportunity, then it became evident that it was much more of a problem about building coalitions and winning the argument, but through a different kind of mechanisms. I was never bucking the entire chain of command because, for example, I always felt completely supported by the Navy and Marine Corps for starters. I never met a military officer of any rank. I never met a JAG officer of any rank who didn't believe exactly as I did on these kinds of questions. So after the first meeting, I consulted with my JAG counterparts in not only Navy and Marine Corps, but also Army and Air Force. All of us believed the same thing. All of us analyzed the issue exactly. And then when I would talk to the Secretary of the Navy or the Commandant of the Marine Corps and the Chief of Naval Operations, as a policy matter, they all believed in the same thing we did as well. Same thing with the leadership of the Army and the Air Force. So it became a point fairly quickly on that the argument with the DoD leadership, Secretary of Defense and the General Counsel, was all the military on one side and these few individuals who happen to have a contrary notion and kept insisting on that. Ultimately, we would learn the support of the White House. Ultimately, Don Rumsfeld rescinded those authorities in Guantanamo, but then circumvented the military by authorizing them with OLC support and White House support.
So is there ever a point at which the government is pushing so hard to do something that seems legally wrong that a government lawyer should consider either quitting or blowing the whistle? Marty, why don't I start this with you?
So, those of you who haven't read the memoranda that Alberto and his fellow colleagues wrote at the time, urging a change in legal analysis and policy. Really ought to. They're really very important documents and remarkable, really remarkable. I wondered this. And it's a question I have for Alberto, I guess. So what if you had known, what if you had found out that notwithstanding your advice that this had continued, at what point do you either leak it or resign? And I ask myself that. I happen to have been in the Office of Legal Counsel at the time these memoranda were being written, and I was, a line attorney, and I didn't know about them, not surprisingly. But if I had, what would I have done? And if I know I would have complained about it and taken it to the head of the office and said, this is just wrong. I would have done, my best. It wasn't a legal issue I had confronted before. I would have tried to look at it carefully and say, this doesn't seem right. Taken it to the head of the office, probably taken it to the Attorney General, maybe reached out to people in other agencies, although I was not really at that level. Okay, but if they just said, you're overruled, what would I have done? Well, any of us in government, we get overruled on legal questions quite regularly, right? It's not, most of the time our advice from OLC is followed by the Attorney General and the President. But there have been times in my years in government where they have overruled me, and no one would think to resign or leak in those cases. So it's not just that your superior comes up with a different legal view. That's not a sufficient reason, obviously, for either leaking or resigning. Someone who doesn't believe that lawyers ought to leak confidential information at all from within the government, I think it's an interesting question whether that's different for lawyers than for other government officials. I haven't really thought that through. So I wonder what I would have done.
But is that because of the duty of confidentiality of lawyers or for some other?
Well, that's what I'm trying to figure out. I wonder whether, non-lawyers have duties of confidentiality to their clients or the people they're working for too. If the president appoints you, you have a duty of confidentiality. So I'm not sure whether, I do know that there's an ethos within the legal profession and within government lawyers in particular not to leak. And my friends in the press tell me that although government lawyers leak sometimes, it's much less than non-lawyers who work in the government. And I think that's because of this sense of confidentiality, even when we think something terribly wrong is happening. And I ask myself whether I would have resigned. And I'm being honest with myself. I was on my way out anyway. My resignation would have been a drop in the ocean. No one would have noticed it. So I'm not sure it would have made a difference other than to make me feel better. I don't know what the answer is as to at what point you leave, and if you leave, should you do so in some sort of way that registers your protest, that at least gives somebody the idea, either within the government or outside it, that something very wrong is going on.
Right. I think maybe short of a leak, call up your friends at the State Department and say, hey, this is going on. I think our agency position historically is against this. We've signed a few conventions that have to do with this. I think maybe short of a leak, this is why there are fewer leaks from government attorneys, is because they turn to the sort of peer review process that we were talking about in the last panel, and just sort of get an interagency dialogue going, and then that maybe addresses it. It's coalition building.
Brad, would you want to jump in on this?
Well, yeah, I'm actually remaining silent for a reason. Other than David, I'm the philosopher on the panel. I'm a theorist, and I actually believe that it is the role for theory here to yield to practice. I read on the flight on the way down this morning one of my favorite books in political ethics, just to kind of remind me about this stuff and get myself back in this mindset. It's called Innocence and Experience by Stuart Hampshire. And he's talking about the problem of the kind of moral idea of innocence that we all as individual moral agents hold ourselves to. We want to do the right thing, versus the experience of a political actor who understands that sometimes in politics and in public life, it's necessary to do something that is a second best, or something that is involved somehow in something that might be dishonorable. It's the classic problem of dirty hands. And Hampshire rightly attributes this to Machiavelli. And he says, here's some wonderful things, and this book is so good. And he says, the morality of innocence is the morality of a people who are resigned to being impotent. Especially when it comes to matters of national security, there are times in which a political actor needs to be prepared to do something that would otherwise seem morally dishonorable. And political actors need to be prepared for this. And so, immediately revert back to this ideal of innocence is just missing the point of being a political actor. But at the end of his chapter on Machiavelli, Hampshire says something really, which is why I was being silent. And he says, philosophy has nothing to offer here. Nothing from the armchair point of view of the theorist that can be said. This is the kind of thing that relies on the experience of wise people who have served in these positions. And so I wanted to sit here and listen to Marty and Alberto, honestly. I, as a theorist, can frame the problem. I can talk about the problem of dirty hands. But when it comes right down to it, somewhat unusual as a law professor and having had a completely banal law practice. I was a defense side tort lawyer. People got hurt with tools and I defended these companies. And I know nothing about this stuff, right? From the point of view of practice. And so I wanted to listen. And I really do think one of the great things about practical ethics as a discipline is that you bring theory types together with people who have actually been on the ground and people who have been at very, very high levels of government and made decisions on behalf of the country as a whole. And I think practical ethics is wonderful as compared with pure theoretical moral philosophy because it really does force you to give concrete substance to these theoretical commitments that you have. So I want to kind of shuffle off to the stage here and listen to these folks.
David's the philosopher. David's another philosopher. I wonder whether David thinks philosophy has nothing to say about this. We were talking last night, I was using a couple of examples. How many of you are familiar with what would have been made the Saturday Night Massacre look like a pittance when sort of 20 or 30 of the most high-level DOJ officials were prepared to resign if President Bush continued to run the terrorist surveillance program. DOJ had said that it was unlawful. And some of those folks I'm friends with, and I just wonder, what was it about that, right? It wasn't the first time the White House said, we're not taking your legal advice, we're overruling you. It doesn't happen often, but it happens occasionally. It wasn't something they thought was immoral. They thought it was actually a valuable program. So it wasn't the illegality, it wasn't the immorality. So what was it that made that they would have had this incredible convulsive resignation, mass resignation from DOJ, with a very popular president in the middle of a war that would have torn the country asunder? And all I could think of was that somehow the process had been abused, that they felt like it wasn't as though the president was making a principled view, I'm sorry, I just disagree with your legal advice, but I'm really committed to rule of law and I come out the other way. But that somehow the president was saying, the Department of Justice, we're going to run roughshod right over them. It's very hard to articulate this or to make any sort of general rule, philosophical or even practical rule. Maybe it's you know it when you see it. You didn't see a lot of mass resignations, for instance, when President Obama decided to continue the Libya operation, when many of the lawyers in the government were telling him it would violate the War Powers Resolution, but a couple were telling him it would be okay. He sided with those, the ones who lost that debate. No indication that they thought of resigning or making a big public issue of it, although somebody leaked it to the press. So maybe that was the way of bringing that out into the public. I have a hard time, maybe it's just practical ethics, coming up with a principle here. I don't think that it's illegal or it's immoral are in and of themselves sufficient. But I'm not sure what is.
Well, so first of all, I'm reminded of a philosopher that I knew who had a sign on his desk saying, I can't solve your problems. My job is to help you enjoy them.
So help us.
Well, no, I'm not going. This is going to be philosophy. This is going to be the rules of professional conduct. If your client is engaged in unlawful activity, then you need to withdraw. And I suppose that it's possible to withdraw from the case without resigning, and stay in the office. But if it turns out that this is actually no different than the private lawyer. If your hands are too close to wrongful activity, then you have to withdraw, or else you become an accomplice and an aider and abettor.
This may not happen in private practice. What if the client says, "I'm fine. You've told me that you think this is illegal. I'm not going to do it anyway, even though I know it's illegal. I have a different view of the law. I think this is legal."
Yeah.
You resign every time, then government lawyers would be resigning left and right.
Good point.
So
maybe, yeah. I guess my own view, which is not going to be philosophically defended, well, maybe a bit this afternoon, is that it depends on what the stakes are of the legality. I mean, if it's if it's a minor disagreement about a minor issue, or maybe even a major disagreement about a minor issue, that's not the point at which you say, I can't continue to work for this organization anymore, because there are such things as good faith disagreements about law, in which the good faith disagreement can be backed by good faith arguments. It's the situation in which you don't think that there's any possibility for a good faith disagreement, that it seems to me at least the formal legal rules of conduct tell that that's got to lead to a parting of ways.
I think Marty raised a good point earlier too that I want to come back to, which is that in the government lawyer context, the state is also the prosecuting entity. And so I'm a former private sector person, and there would be things that were a little dodgy, and you could watch associates all over the firm covering their ass because they were afraid that if something bad happened, they would be on the hook. And people were constantly writing memos to the file saying, I gave this advice. And I teach in my professional responsibility class cases in which there's an associate sitting at counsel table in the party committing some wrongdoing, and the associate knows something bad is going down, does nothing, and gets whacked with discipline. And I say to people, look, you're on the hook, folks, and you're on the hook for professional discipline, and you're on the hook for legal malpractice, and it happens all the time. That's just less of a possibility in the government lawyering context. And it is generally true that it's the junior people who get thrown under the bus. There's a lot less likelihood of professional discipline for sitting around and letting illegal conduct occur. Whereas in the private sector, if you do that, if you give advice on a deal and the deal blows up and a bunch of people lose money, they're going to sue the law firm, and there'll be a deposition, and your conduct will be exposed, and you're on the hook. And so the practical constraints are different. The rules of professional conduct are the same. They apply equally to government and private lawyers. But as I always tell my students, no one at a big sophisticated law firm worries about getting disciplined by the state bar of state X. They worry about getting sued. And so the liability picture is very different for government and private lawyers.
Okay. I suspect at this point we've got about 20 minutes left, that there might be 20 minutes worth of questions and answers from the audience.
David, just before we lose this thread, I don't want to put you on the spot, but Alberto, have you thought about what you would have done had you known that the practice continued, notwithstanding your advice?
Yeah, I've thought about that, and like you, it depends, and I'm not really sure. Now, I thought I might resign twice. When I went to Rumsfeld the first time for over several weeks, and finally, when I threatened to put my analysis, my views in writing, and I gave my draft memorandum to the DOD General Counsel, Rumsfeld that day rescinded the interrogation authorities, and coupled with NCIS, who had the proven ability to know what was happening on the ground in Guantanamo, came back to me and said, the abuse has stopped. So it was both the formal notification, which was good, gratifying, but then coupled with law enforcement coming back to me and verifying that the desired action had taken. So that crisis was avoided. The next time this came up was when President Bush threatened to veto the Detainee Treatment Act, which barred the application of cruel and human degrading treatment to all persons in captivity anywhere in the world held by any U.S. government agencies. Had the administration made good on the threat and vetoed the act because they wanted to continue to apply cruel and human degrading treatment to people around the world, that might have been a break point for me. I may have contemplated resigning on the spot if that happened. But otherwise, I felt I had a lot of room to run. I had a lot of runway. I had a lot of tools. I was in there to win the argument. I was in there to protect the president better than the other, give better advice others had given, help the country. So I had not maximized and not exhausted the use of the tools available to me to change the law and change the policy. That's where I don't know how far I would have gone had I not been able to achieve a success using these other tools.
We've been talking about what the line is between when a government attorney would resign and not, and all that. And I think maybe it just comes down to who are we as a country and who are we as the United States? I mean, we're, free home of the brave, and there are certain things that you will defend in court that would not compromise this U.S. identity. We're a country that doesn't discriminate. We allow freedom of association, freedom of religion, all these. But when you start talking about torture, and we're going to be the home of the torturers, really? Is that what we're going to be? That's, I think, when it really crosses the line, because people that go into government service, and I know this is a person who's not in government service right now, you give up a lot of money. You make compromises about your professional life and about what you're going to be able to do, what you're going to be able to say. And you do that because you believe in the United States and who we are as a country. And if you're being asked to defend a policy, as a government lawyer that you think is going to blacken the name of this country, I think that's when you have to draw the line.
I'd like to start actually by asking the panelists a very touchy question. David, you talked about government lawyers becoming complicit when they don't resign under certain circumstances. How far would you take that? Are they literal accomplices if they knowingly give the government advice to engage in activities that either depend on twisting the law, shading the law, taking liberties with legal interpretation? Should they actually be prosecuted for the activities they are advising as accomplices?
Yeah, I think those are actually two different questions. I think the answer to complicity is yes. To knowingly assist a client in unlawful conduct, it's a disciplinable offense, so that the lawyer could, at least in theory, lose her license for it. And if the action is criminal, then it makes you an accomplice to the crime as well. Should they be prosecuted for it is, I think, a very different question. And there, I'll just put two considerations on the table. The first is that you shouldn't prosecute somebody who can't prove it. And proving the element of knowledge can be extremely difficult. And I think the case in point would be the torture memoranda, which are 50-page, closely reasoned legal arguments about why enhanced interrogation isn't torture. If you've got that behind you, how is somebody going to prove that you knew it was torture if you stand by your opinion? If you can't prove it, then you shouldn't prosecute. And the second is a much more practical answer. I've thought about this a lot in the torture example, and that is that if you think that juries will always acquit patriots who have crossed the line for patriotic reasons, then maybe you don't want a long record of acquittals in these cases because it makes real bad law.
Do others on the panel want to speak to this question of prosecution?
I just wanted to get back to David's Lord Goldsmith example, though. So before the action's taken, he's giving his best view of the law to the executive officials, and then they decide to go against his best view of the law, and he's asked to change habits and become an advocate to the parliament. So is that, I think you should ask a different lawyer to do that, a litigator or someone. You shouldn't ask the person who's giving advice X to go to another audience and say, tell them not X. But do you think that's problematic, his presentation to Parliament? And should
I think that was a classic dirty hands dilemma for the following reason. He's not supposed to be an advocate to Parliament. The formal posture of that is you are the Attorney General of the United Kingdom and you are informing Parliament about, you are a legal advisor.
It's different from a court then.
Yeah, but in fact, since it's out in public and the war's already been launched, it would be, to say the least, really awkward politically if the Attorney General got up and said, well, you know what, maybe we sent our troops into action on a potentially illegal war.
Can I just point something out as a teacher of legal ethics that I find gratifying, and that is that this discussion is proceeding as if there is a distinction between a well-grounded legal argument and one that's kind of bogus. In response to Claire's question, criminal law may be a blunt instrument or too blunt for regulating this problem, but I do really get my hackles up when people say, well, what is the law anyway? Lawyers can make it mean whatever they want. It's instantly manipulable. And whenever I get that question in a workshop, because I write about fidelity to law, I always say to the questioner, do you grade exams that way? Is that the working assumption that you have about a problem that you put to your students? Do you really think they're kind of all on a par, or do you just throw them down the stairs? Or do you really think some of them do a better job of getting it right than others? And I think, the memos that Marty's been alluding to, if you look at some of them and you just view them as an exercise in statutory interpretation, just run them as a statutory interpretation exercise and ask yourself, how well does this memo do at unpacking the meaning of the statute? And I think any impartial lawyer would go, this is terrible. And we can talk about the ethical obligations that follow for litigators or for advisors or whatever, but I'm just happy that the predicate has been put out there and no one seems to seriously challenge it, that there is a distinction between well-grounded legal advice and kind of spurious or abusive.
We have colleagues on our faculty who would challenge it all.
I've had that question at your school, so yeah.
Brad, if the interpretation is poor enough, should that be a basis by itself for proving scienter?
I do think it would be. I'm a little maybe out of the mainstream on this, but I again come out of this on the private lawyer side. There are all kinds of criminal cases against lawyers who participate in drug conspiracies or things like that, where they advise clients to do something and the mens rea to provide substantial assistance to the commission of a crime that makes them accessories after the fact. So there are cases in which legal advice can be the substantial assistance of a crime. So, if the advice is bad enough, I think the inference of mens rea is there. Now, is beyond a reasonable doubt? David's point or Marty's point is a fair one. This is a long memo. Maybe you can't get beyond a reasonable doubt there, but boy, it sure smells bad to me.
Let me add something here, because I think I acknowledge as well and agree upon the difficulties of prosecution in these kinds of matters. But let's look backwards for a second. Where are we today as a nation? I think first of all, let's recognize a point that indisputably we tortured. I mean, there's no real debate about this any longer. That there are a number of cases where the evidence of application of severe pain was so clear as to be not seriously debatable. So where are we now as a nation? We've distorted the legal standard. First of all, it's a distortion to be talking only about torture. Our legal standard is really cruel, inhuman, and degrading treatment. We should be talking about potential criminal sanction against those who applied cruelty, not merely torture. But we've changed the standard, and we've also eliminated accountability from the arena. So we have a situation where we've broken the law, but we held no one accountable for this. And this has severe consequences for our legal system, has severe consequences for our foreign policy, our moral authority, our ability to help construct the kind of world we all would like to live in. So it's an undesirable place to be. Accountability is politically unthinkable today, but it's legally unthinkable for us not to seek accountability. And how to resolve these two things is the dilemma we find ourselves in.
This is an incredibly complex topic. David's writing on it right now in a really, really elegant chapter of his book. The problem in this case, it's such an odd case, is that the legal advice here was approved and then acted upon by the President and the Vice President of the United States. And to me, it would seem odd in that context to go and prosecute lower level officials if you're not willing to hold accountable the head of state, which is something that is, for 1,000 reasons, unthinkable.
Right.
And so, although in the abstract, I agree with Alberto that it would be better if there were some cost, and I do think there have been some costs, to having done this, it's not obvious to me what the remedy is here.
I would trade past accountability for future clarity, for return to the clear standard in line with international standards in American law, and the resolution on the part of the that we will exercise accountability going forward. But I'm not sure that we're.
If there were a way to guarantee that, President Obama has said we tortured and we were wrong and we'll never do it again. But he won't be in office for the next 100 years. So
I'm encouraged by the 2010 statement of best practices. I thought OLC recognized that it had to reestablish its credibility as an office that gave impartial advice, and I thought that was a significant step.
I'm saying there are little things like this, but
I think we have some other questions.
Yes, ladies and gentlemen of the panel, Kevin Govern, you saw me up front a little while ago. I'll play devil's advocate with this following question. Are lawyers, in fact, the best ethical watchdogs from a government perspective? Let me set the stage for this in tribute to Mr. Mora. It was John Paul Jones' 1775 Rules for Regulation of the United Colonies that established principles that presently are the exemplary conduct standards for all of the armed forces. I was talking with Ambassador Daley a little while ago. Inspectors general are the eyes, ears, and conscience of commanders, and often are very integrally involved in the investigation of and the advancement of ethical standards. And last but not least, we have a real commander amongst us, presently serving, Colonel Wilcox, whose daily responsibility is to imbue a sense of professional military ethic. others of us who are in the audience that have lived that, have benefited from that. So I pose the question again. From a non-lawyer-centric perspective, as difficult as it may be for each of us to do this who are lawyers the best watchdogs of ethics when there's so many others that are responsible for imbuing and living those standards?
I think no. But here's where I come at this as a lawyer and a teacher of lawyers. I heard two people this morning where the journalist said, trust us, and the scientist said, trust us. And I'm sitting there thinking, I don't trust y'all. And it's not because I trust lawyers. The watchdog is the law. Lawyers are part of a complicated institutional mechanism through which the law constrains the decisions of scientists and journalists and military officers and lawyers, right? I mean, the class I teach is called The Law Governs Lawyers. So I believe that we are part of a system, but the rule of law is watchdog here. I don't mean to personify it. I understand it's this kind of artifactual thing, but we help implement something that is bigger than us. And I'm not saying that lawyers are the watchdog. I certainly wouldn't throw it back on the individual ethics of lawyers. I think the conversation we're having here has been about faithful legal advice, where the law is standing in the role of the watchdog. And that's true for all of the contexts that we've been talking about today.
And I think part of also the lawyer's duty to talk to all those individuals who have the facts on the ground. I mean, the fact that the lawyer, your job is to know the law, but you're not going to have the sort of substance expertise in, say, medicine or through military tactics. This is an issue of your client relationship and doing a sort of investigation and taking that time before you get a legal opinion. So no, I think lawyers are not the end-all be-all. I think it should definitely be a dialogue.
I'll actually stand up for lawyers as ethical watchdogs because lawyers are trained in a subject which involves listening very carefully to arguments on all sides and looking at every issue from multiple points of view and thinking that facts matter a lot. I mean, they're not unique in thinking that facts matter a lot, but I think the special training of lawyers is in bringing abstract principles and concrete facts together. And I don't think that lawyers have a monopoly on this kind of wisdom. I don't think that they're top on all of these things, but they're not bad. And I think that especially given that the lawyer's job is supposed to be to offer independent judgment, if it's independent judgment that you're looking for, then I think you could do a lot worse.
Can I add something to what Kate and David just said, which is this is just present every day in government lawyering. If you're doing your job right, you are trying to look ahead into your client. I know you really want to do this, but are you sure you want me to answer that question? Thinking the answer to the question might be yes, you can do it. But the client really needs to understand the implications of a lawyer in the government saying this legal theory is okay, will be for the years to come in other nations, with other presidents, with other attorneys general. Do you really want to go down that road? You're not just asking me about whether this operation could take place next week. You're asking, do we want to do that? And very often the best legal advice is to persuade the client that they don't want to ask the question in the first place.
I spent a good bit of time towards the end of my tenure at the Pentagon trying to bring policymakers' attentions to the policy consequences of these legal decisions, which is one of the failures of my administration, the Bush administration, on this particular issue. It wasn't only that the law was broken, but the policy consequences were significant. And one of the arguments I made, and there are a series of arguments about this, but you look at American foreign policy for the last 60 years, we sought to accomplish a number of things, but one of them was protecting human dignity through the rule of law. Now, what does it mean that all of a sudden the United States pivots and thinks that it's okay for a state to apply cruelty to individuals? Well, it blows a hole in the side of this entire human rights construct and the construct of human dignity and what we were seeking to accomplish. So one of the questions I posed in the Pentagon was, who made the decision that it's more important to interrogate a dozen detainees cruelly than it is to continue to work, as we have around the world, with such success to promote the rule of law that observes these kinds of principles? Because the two positions are incompatible with each other. And we had advocated and reversed course on the foreign policy side by adopting our interests on the interrogation side. The issue was never fully pursued at the Pentagon.
So Kevin, I mean, I think Alberto's memo is a perfect example of this. I don't know whether you call that ethics or not. I just call it good lawyering. And so it's sort of built into the very project.
Each of us as effective lawyers realize that being counsel means more than simply getting legal counsel. And all of you have lived that in your clients'
Okay, I think we have time for one more question, and I see Jonathan has one.
Jonathan Marks, thank you very much. Just sort of following on from that line of discourse, there was an exchange, David, between you and Marty about when you stand up and say no and blow the whistle. And I want to offer one possible answer to the question you were playing with. When what you're talking about is an opinion, which in the case of the, as you characterize them, cover your ass, the CIA memos in relation to torture, when you're talking about participating in a process that essentially is not just complicity, but licensing fundamental human rights violations, which are themselves serious international crimes under international law, doesn't that provide a clear example of a case where one would stand up and say no and potentially blow the whistle?
Anybody want to answer that?
So if I think my client is breaking international law, not just domestic, that's the time to...
No,
what do you mean by blowing the whistle, for one
not
thing?
just international law, but a fundamental norm of human rights under international law such that its violation is a serious international crime.
Well, that's what I was suggesting. It can't just be that any violation of law is enough to blow the whistle. I don't know whether it just being horrifying and immoral is enough, or whether it's what Alberto's saying. You're doing something to undermine a norm that has, we've expended a lot of energy over a number of years to try to make that norm work. It's hard to articulate, but I'm curious what you mean by blow the whistle.
Well, I mean, the first thing is I'm emphasizing that it's a fundamental norm of international law that such that its violation constitutes a crime under international law, which all sorts of other implications follow, including, for example, crime that attracts universal jurisdiction, which means you can be prosecuted anywhere.
So you think a lawyer should do what?
So then the question is, obviously not participate in the process, but then I'm turning the question over to you, and more than not participate in the process, is that the moment when you have an obligation to resign, and also do you have an obligation then to speak out? That's what I'm...
But that's the hard question. Do you breach your obligation of confidentiality? I don't know what the answer to that is. I have a pretty strong sense of my obligation of confidentiality, but I think that's a really hard question.
We can't answer your question, but we can help you enjoy them. So I would like to thank the panelists for their incredibly thoughtful and important contributions.